session, S. Rajendran sir, the Regional Director at SIRO of ICSI, DVNS Sharma sir, and all the dignitaries who have joined us today in this roundtable discussion. Good morning to all of you. Today, as you all know, we have gathered to discuss two very important papers.
Nitinji, your voice got muted. Yeah.
Is it audible, sir?
Yeah, now it is audible. In between, okay. Suddenly it got muted.
Okay, sure, sir. So, as I said, that today we have gathered to discuss two very important and recent discussion papers quoted by IBBI. The first one is on streamlining liquidation process, and the other one is enabling IPEs to take up assignment as an insolvency professional. So those discussion papers provide the rationale behind the proposals that are made in the discussion papers. And I'm sure that everybody has gone through it. And today we have the privilege of having Rajendran sir, who has expertise into this particular field of law. Sir shall be sharing the proposals, the rationale behind them, and also enlighten us on different aspects of the law. And we will be delighted to have your views on board. So with that, I can I'll just take 2 minutes to very briefly introduce. Sharma sir, can we go about like this? Can I take 2 minutes to introduce sir?
Yeah, please go ahead.
Rajendran sir. Okay. Just a second. So S. Rajendran sir is, as you all know, he's a registered insolvency professional. Other than that, sir is a director at Create Grow Research Foundation, which is a Section 8 company. Apart from that, sir is also a managing partner at SR Streamlining Company LLP Chennai. If I talk about the previous experience, sir was the chief operating officer at Pioneer Wincon Private Limited from September 2002 till June 2014. Prior to that, sir was senior manager finance accounts at Wheels India Limited from January 2000 to August 2002. And I'll just mention one more and leave the other one. So sir was also the secretary and BGM finance at Pondicherry Papers Limited. If I come up to the education, sir is a fellow member of ICSI, Institute of Company Secretaries of India, is also ICMAI. Sir is also a CAIIB from Indian Institute of Banking and Finance. So with that, I'll just cut short my part, and I'll straight away request Sharma sir and Rajendran sir to take it forward. Please, sir, over to you.
Thank you, Mr. Nitin. Very good morning to all the participants and warm welcome to this roundtable discussion through online. It is a good initiative taken by our ICSI IAP and with the support of Rajendran sir. I hope a lot of inputs will come from all of you so that it can be compiled and can be submitted to IBBI for further needful action. And I request all the participants who may not be able to give their feedback now itself or inputs now itself, may can give to the email ID provided by Mr. Nitin Satija, so that all will be compiled at Delhi level and they will consolidate. So I request Mr. Nitin to provide one email ID so that any member who wish to give further inputs apart from this deliberation today, before today evening or by tomorrow afternoon, something you fix a cut-off time so that the members who are all present here can give their feedback or further inputs on that. So I request all of you to give that inputs to Mr. Nitin Satija. He will be providing in the chat box the dedicated email ID so that you can put forward all the inputs from your side. And thank you very much for participating in this. Now I request Rajendran sir to take over. Rajendran sir, over to you.
Thank you very much, Mr. Sharma, and thank you very much, Mr. Nitin Satija from ICSI IAP. Thanks a lot for the great support from ICSI, the institution, which takes care of all of our fellow professionals as company secretaries. And it gives me a lot of pleasure and satisfaction that there is an opportunity for all of us to be in this profession of insolvency resolution as well as liquidation. And also, this particular opportunity gives me a platform to share rather moderate the views, the opinions, the comments of the fellow professionals. And I am glad to see, a cross-section of the insolvency professionals, someone like a gray hair with me, like me, or people who were much younger and still exploring the insolvency resolution. Like I can see Mr. Mohit Arora on the screen. Of course, he is on mute. So Representative Mr. Narayan Nageshwaran sir, I'm seeing on the screen. Okay, so this particular profession is now having a versatile combination of very senior people, experienced people, as well as upcoming youngsters. So I can see a good kind of a combination. And the topic which we are going to discuss today, the discussion papers, surprisingly, they also offer a contrast. The liquidation, I can say it is a sunset clause where things are going down on the road, reaching the end of the road kind of a situation. Though in strict sense, in IBC, liquidation doesn't actually mean liquidation. Like a phoenix, takes birth from its own ashes. Even in liquidation, also some companies can be sold as a going concern. So that is the beauty of IBC. So one topic which we are going to discuss, threadbare, get your views, analysis of the new amendments, the proposals. One is on the sunset clause, which is the liquidation process and how to speed it up, how to improve the liquidation process, streamline the liquidation process. The other one is a beautiful concept of emerging sector, a sunrise sector, a kind of a proposal where the insolvency professional, the kind of a discharge of the obligation, the professional's duty, can it be given to a corporate entity? So a juridical person, can that entity become an insolvency professional? So ladies and gentlemen, with these two topics, setting the context on these two topics, I would like to quickly run through a 4-minute presentation, which I will not take deeper into the things. I will come back to you again for a one-to-one discussion on these proposals in detail. So I will just run through this quick presentation. I'll ask my friend, my colleague, to share the presentation from our side. So the two topics which we have been discussing, streamlining liquidation process, and the other one is enabling entities to become insolvency professionals. Okay, so let's go to the streamlining liquidation process. What are all the things we are going to talk about in that thing? So the discussion paper has been issued by the IBBI on 14th of June. The last date for comments is today, 5th July 22. So I think it will be fresh in our memory after our discussions for you to post the comments and suggestions to the IBBI website, as well as to the email ID Mr. Sharma and Nitin were talking about. There are 15 proposals. Okay, the 15 proposals, of that, the important proposals are listed here in 2 slides. And, just to rush through these important proposals, the Committee of Creditors Dispensation will continue in the liquidation process as well until the Stakeholders Committee is formed in 60 days. And the other one, the first Stakeholders Committee meeting shall be held within 7 days of liquidation commencement date. So these are all the important proposals. And the third one is a decision on relinquishing of security interest by secured creditors should be taken within 7 days of liquidation commencement, or in the first SCC meeting, whichever is later. In any case, it cannot be beyond 7 days. And the SCC will now be armed with the powers to replace the liquidator with a 66% voting share. And the continuation of these important proposals, the SCC can fix the liquidator's fees in the first meeting. Somewhere, the word fix or review is appearing. We'll discuss it in detail. The next important thing is that only 30 days of time is earmarked for Section 230 process under Companies Act, unlike 90 days, which has been there earlier. Then the next one is the asset memorandum to be prepared in 30 days time from liquidation commencement, and that has to be shared with the stakeholders consultation committee under confidentiality, as against the existing stipulation that such asset memorandum shall be a confidential document and shall not be shared with anyone. That is the current framework. Now there is a dilution in that. Next one is valuation to be done if SEC so desires. So this is the next one. Interim finance interest. It was earlier capped at 1 year. Beyond 1 year, there was a question that such interest will not be forming part of the insolvency or liquidation cost. So that cap has been removed now. And the other proposals, which are ancillary incidental to the the liquidation process streamlining, is on the progress reports to be shared with IBBI along with the adjudicating authority. Auction platform to be notified. There are platforms for distressed assets notified by IBBI as well. Timelines for auction process has been completely specified, and avoidance transactions pursuing such applications, how that process will be continued, the manner in which such applications will be pursued, and when there is a clawback of the proceeds out of such proceedings, how the distribution will take place. This has to be recorded by the stakeholders committee before it goes for the dissolution of the company. And the last one is the CARP claims, whatever the resolution professional received, and the liquidator, when he is compiling the receipt of claims from various people, if someone has filed a CARP process, but he hasn't come in the liquidation process, so such claims can be taken, can be considered by the liquidator. So these are all the important things. And of course, I would like to discuss later on whether withdrawal under Section 12A could be a subject and whether there can be any ceiling on the number of cases for liquidation. Okay. Gentlemen and ladies, you may all might have heard, if someone coming from this part of the country, the southern part of the country, in Tamil, they used to call, it's just see how you can get a marriage done or how a house construction can be done. Kalyanam pannipar, Vitai kattipar, abin Tamil la solvanga. Nowadays, even to liquidate a company, it takes hell a lot of a time. The kind of, time, the process and the proceedings, that itself takes a lot of time. So I think in that context, the efforts of IBBI, definitely I think we should appreciate the earnestness in which those proposals have been suggested for consideration by all the professionals. Okay, I'm now taking you to the just previous one. I'm now taking you to the second part of our discussions is on the allowing the entities to become insolvency professionals. So this paper also was issued IBBI on 14th of June, same date for comments, last date today. And thankfully, the number of proposals what has been made is one, but it's definitely a kind of a thought-provoking proposal. A lot of implications, a lot of caveats are there, liabilities are there, fees part of it, a lot of discussions are there. So how is it the IP to IP, how the proposal, can you go next one, will be there. There are only two kinds of, two limbs of the same proposal they have made in the IBBI discussion paper. The one is to allow existing IPs to become IPs, since they have the infrastructure, requisite exposure in providing support services to IPs. And as a corollary to the first proposal, to allow the existing IPs, after seeking registration as insolvency professional, to continue to provide support services to IPs. This is the exact situation of the proposal given by the IBBI. There are certain important aspects which we need to take note of. How an IP is getting morphed into an IP, how the the process from IPE to IP, how it takes place, what are all the kinds of additional restrictions or additional provisions, caveats which upon fulfilled by the IPE is eligible to become an insolvency professional, like, as much as the individual insolvency professionals. So this is the kind of a situation. The last, I think you can see, it cannot be a subsidiary, JV or associate of another company or body corporate, should not be undergoing insolvency resolution process, or is an undischarged bankrupt, and all directors, partners should be qualified insolvency professionals. I think there are a lot of plus and minus could be there. I think this is where we are here for discussing the advantages, as well as if there is any kind of shortfalls or pitfalls or disadvantages, we will be discussing that. So lastly, there are more than 4,000 individual IPs are there. And as correspondingly to that, the number of IPs, if I get the numbers from IBBI website, is hardly about 3.5% of the individual IPs. 140 IPs are there. So, ladies and gentlemen, this is what I would like to just present as a kind of a context for our discussions. So, we will go back to our the first topic, the one on the liquidation. So, ladies and gentlemen, I will just remove this presentation part of it from the screen now. Now coming to this liquidation paper, streamlining the liquidation process, there are 15 proposals, as I had shared briefly there. So all these processes, the 15 proposals, have come out of the practical situations faced by the liquidators in their liquidation process. And I'm seeing here 1,320 liquidation cases have been there listed out by IBBI in the discussion paper, of which more than 79% of the total cases they form part, and almost half of the cases of the liquidation process, they have already crossed 2 years' time. And the time-bound process of the liquidation is not happening. Okay, so reasons could be many. Okay, there are several contributory factors. One could be the COVID factor, which has come in between after 2017, 18, 19, 20. After 1920, we had the COVID factor. But even prior to that, there has been a lot of delays in the liquidation process. So straight away, going on to the first, the proposal is on the streamlining of the SCC, the Stakeholders Consultation Committee. So,
Rajendran sir, just a small request,
yeah.
Sir. In case if anybody finds a mismatch between what has been suggested and the language that is employed for amendment in the regulations, so that can also be pointed out to IBBI. So
absolutely. Nitin, by the way, Nitin, is there any representative from IBBI also present here in this forum?
Not today, sir.
Oh, okay. Okay, fine, Nitin. Yeah, that's the point. The members who are here, the learned members, professionals in their own, respect, and also the insolvency professionals here, in case you come across any kind of suggestion to improve the language deployed here in the amendment or in the proposals, you are most welcome to make the suggestions for appropriate changes or modifications. So the number one point is on the streamlining the constitution of the Stakeholders Consultation Committee. So members may be aware, all my friends, that immediately after a company goes into liquidation, the COC does not exist, RP does not exist, liquidator takes control of the company, and he runs the company, wherever it is a going concern. Otherwise, the liquidator dons the role of an adjudicator. He invites the claims and then adjudicates on the claims, and thereafter he goes about preparation of the asset memorandum and the auction process for realizing the money. And I think in 2019, the Stakeholders Consultation Committee concept came into picture, where apart from the liquidator, the stakeholders also will be forming part of the dispensation, even though they may not have any powers. So I think it is Regulation 31A was introduced, of stakeholders committee. But the composition of the stakeholders committee was not by means of the value of their claims, but by the number of the people. Unsecured financial creditors will be there. Secured creditors who have relinquished their interest will be there. And I think as per section 31, regulation 31A, you had only a few people, 2 financial creditors, and then 2 operational creditors, 1 representing employees, 1 representing government dues, and then there will be 1 representative for the shareholders of the company. So on a whole, if you look at the composition of the stakeholders committee, it would be like about 5 or 6 people. And within that 5 or 6 people, the decisions will be taken by 66%, something like that was there. Now, as against that, this case, in this proposal number 1, it is suggested that the COC as constituted during CARP period on the basis of admitted claims shall function as the stakeholders committee during liquidation process with the same voting share of the members, and the stakeholders who are part of COC without voting rights will also be part of the stakeholders consultation committee. For example, the directors of the corporate creditor, any operational creditor who is having more than 10% of the debt. So they will continue to be part of the stakeholders committee. Meaning this will be a kind of an interim stakeholders committee where the transition from the CARP period, the same COC comes and takes charge of the liquidation process. The liquidator shall convene the first meeting of the SEC within 7 days of the liquidation commencement date. So earlier there was no fixed date for convening the committee, stakeholders consultation committee. I now request the members, the participants. According to my understanding, this proposal definitely gives a kind of a speed to the process that you don't have to wait for the claims to come, adjudication of the claims to be completed, then forming the SEC. Till the time you don't wait, you just get the same COC on board and continue with the process. Any suggestion or any views from the members on this particular point? Can you just little down? Okay, the second limb of the proposal, I think it introduces a little bit of a complexity in the process. If you can look at the second paragraph of this proposal, after adjudication of claims received from liquidation process and within 60 days of LCD, composition of the SEC will be changed with stakeholders having voting rights in proportion to the share of payments they will receive as per waterfall mechanism in section 53. If the liquidation value as per the latest valuation available is taken as the proceeds for sale. I think it's a pretty long sentence with a lot of clauses. And also as a continuation, in case the valuation is undertaken subsequently, voting rights of the stakeholders may be revised accordingly. Why it has gone? Okay, so the second part of the proposal, I think it introduces a little bit of a complexity and complication. It says that how the COC will change into SEC after the claims are determined within the 60 days of time. It says that the composition of the SEC will be changed with stakeholders having voting rights in proportion to the share of payments they will receive as per waterfall mechanism in section 53. If the liquidation value as per the latest valuation available is taken as the proceeds for sale. So I think if I may invite comments from the participants, is it because of, sorry? Yeah, is there any question from any of the participants, please? Mr. Jayagopal Venkatraman.
Good morning, sir. I have a question on proposal number 1.
Yeah.
May I ask this question, please?
Yeah, please.
See, when I function as a liquidator, when I held the meeting of SEC, no one came for the meeting. So if this system new proposal is introduced and if people don't come and attend the meeting, what would happen subsequent to that? Whether we have to go for the second meeting?
Okay, in order to avoid this situation, probably, the first 60 days period, the existing COC will come into picture. They will be there on board just to continue the process.
Okay.
So that's a kind of a, face saving.
Okay.
I request the members who are not speaking kindly mute. Some disturbance is coming. So Jayagopal sir, if
yes,
stakeholders committee is formed and thereafter nobody is coming, then I think, sir, it's their own headache. It's their own funeral if they are not going to take part of it. Otherwise, liquidator is having his own, area of work, discharging of responsibilities.
Okay.
So in this suggestion, in this paper, the complexity which has come as compared to the existing 31A regulation, which talks about, certain number of people, for financial creditors, certain number of people for operational creditors. It is the current one. But here, if you look at here, I think my friend Ms. Deepa Venkat is also part of the discussions. I may like to request her to share her views. You just see the second line, composition of the SEC will be changed with stakeholders having voting rights in proportion to the share of payments. What do you mean by share of payments? Normally, in proportion to the claim admitted. That is the word normally used wherever there is any list of creditors or list of stakeholders. It is in proportion to the claim admitted. But here, it is in proportion to the share of payments they will receive as per waterfall mechanism in section 53. Another point, another clause introduced is if the liquidation value as per the latest valuation available is taken as the proceeds for sale, which means the liquidation value already calculated, arrived at by the RP will be in the hands. And if you take that as the proceeds for sale and find out under section 53 waterfall, who will all get how much, okay? And that will be the stakeholders committee in proportion to that waterfall mechanism. So according to, my understanding, there is kind of a, incongruity in this arrangement. It is not in proportion to the claims admitted. It is in proportion to the payment which may come under the waterfall mechanism. May I request the comments from the learned members, participants here, whether is it a correct kind of a proposition, or should it be like, maybe there is a plus point here in this argument that not all the people who are not going to get the money in the liquidation process need to be in the stakeholders committee. Only those who are likely to get some money in the liquidation process, they need to be sitting in the liquidation stakeholders committee during the liquidation process. It appears to me like that. So may I invite comments from the members. Deepa, are you there? Okay, any other member, please? Can you see the list of members? If you just go back a little, one paragraph, go back. What is the logic for providing this stakeholders basis? One second. Can you highlight the last sentence in para 5? The present composition of the SEC includes a representative of all classes of stakeholders, irrespective of the amount of their claims, in proportion to total claims against the CD. Okay, so this is the kind of a situation currently existing. The stakeholders committee will be like this. But in the new dispensation, it is linked to the amount which they will get. So I think this is a kind of a path-breaking proposal, and this is going to involve, for example, in many companies, the liquidation value being, much lesser in quantum, and a lot of creditors will be there. And in the waterfall mechanism, if there is a CARP cost, liquidation cost, unpaid, that will go out of the waterfall mechanism on priority, then secured creditors. Then if the amount left out is not going down the line beyond the secured creditors, then there is no need to have any representation in the stakeholders committee for operational creditors, also for the shareholders. I think this is going to be looking like the composition. So any comment on this topic, sir?
Sir, Nageshwaran here.
Yes, sir.
As it is going down, I mean, some of the proposals later on, even with regard to the valuation also, there are certain ideas given in the same IBBI proposal paper.
Correct.
Now, that will change the liquidation value also, because this liquidation value is what has been taken as on the liquidation CARP commencement date,
Correct.
which could be more than 2-3 years old.
Correct.
By the time this company gets into this type of a liquidation. Thereafter, when you are doing a revaluation or a valuation as per the provisions given in the same memorandum or the paper, then it could be for a different date and a recent date, which could be plus or minus.
Okay.
No, technically, if it was a silent factory for additional 3 more years, when the commencement of CARP was there, it was already 3 years silent factory.
Correct.
Now, during the CARP process, another 1 or 2 years, 3 years would have gone away. Another 3 years, the factory would have been silent for more than 6 years now.
Okay.
Technically, the valuation, whatever was taken as on the even commencement date of CARP, will become almost nil as of the liquidation commencement date.
Okay.
So that point is not covered here. So liquidation value, taking the liquidation value, and also as you told, after adjusting it for the liquidation cost as well as the CARP cost, anything, then what is going to be left out will be a situation. And as another member pointed out, as Jayagopal sir pointed out, already SEC members are not having any interest to come into the SEC meeting.
Correct.
Now, all the more the SEC, even if you are going to say that it will be only 1 or 2 of the financial creditors or the creditors who will be getting as per the waterfall mechanism some payment, they will be coming. They will find that right from the beginning, there won't be any interest to get into the SEC at all.
Absolutely correct. Yeah, in some of the liquidation matters handled by me as well, Mr. Jayagopal, particularly in the government dues, like the PF authorities or income tax or GST people, they come and participate in the meeting, but they would not like to become a representative of the class of creditors. Sir, I would represent my organization. Please don't take me as the representative of operational creditors, statutory dues. Don't put me in my name there. I don't want to get into my problem. I will represent for my organization. So this is the kind of a situation happening in the liquidation process. I think there is some kind of an aversion. People want to be away from the process, the liquidation, the process, because there is a liquidator. Let him take care of all those, duties, responsibilities, and obligations, what I should do. So I think in that context, if you look at really, that is why this suggestion number 1, proposal number 1, may end up with only a very few number of participants in the stakeholders committee, number of members in the stakeholders committee, because if you are going to go by the amount which will be received by the stakeholders, if that is going to be the basis. Now, the second point of the proposal, it gives certain kind of a muzzle to the, the stakeholders committee. Earlier, I think regulation 31A said that the decisions taken by the liquidator before the formation of the committee shall be placed before the SEC for information. But now by virtue of this second proposal, the agenda for deciding on certain aspects like remuneration of professionals, whether sale under regulation 32 as a going concern, including the manner of sale, pre-bid qualifications, reserve price, amount of earnest money deposit, all these things, marketing strategy, everything has to be placed by means of an agenda note before the SEC. Please look at, the kind of pressure on liquidator. The liquidation is ordered by the NCLT within 7 days. The first meeting should happen. The first meeting should be convened within 7 days. And in that meeting, the liquidator is expected to put all these things for discussion and also a decision by the SEC. Okay. So the SEC shall advise the liquidator by a vote of not less than 66% of the representatives of the consultation committee present and voting. And now, wherever the liquidator does not want to go by the views of the committee, so here there is an obligation now cast on the liquidator. What is that obligation? He shall record the reasons for the same in writing and forward the records relating to the said decision in a separate form, at another form prescribed by the board, IBBI, to the adjudicating authority and the board within 5 days of such decision. I think this is going to put additional responsibilities on, not only responsibility, also a kind of a compliance pressure on the liquidator. Okay, on this point of proposal, it's good in a way that all these matters are placed before the erstwhile COC, because in the first meeting they are only going to be there. Okay, so any point on this, any suggestion on this second proposal from the members? I request the members for airing your views. Don't hold back. Even whatever views are coming, it's good. We can just discuss on that. Yes, Mr. Jayagopal.
Sir, the question is, the adjudicating authority takes its own time due to various genuine reasons to dispose of cases, where the liquidator takes a different view other than the views of the SEC, and he puts up that interlocutory application to adjudicating authority for approval. Possibly that may take some time, take a while, maybe a month or so. The process, whether other compliances relating to the time frame, will it not get affected?
Yes. Yeah, it will get, it will be there. What you are saying is after the liquidation is ordered by the...
Yes, sir. After the liquidation order has been released by the adjudicating authority, and within 7 days, we have to hold the stakeholders committee meeting, and the liquidator takes a different view.
So you are only supposed to file the records with the board as well as the adjudicating authority.
Okay.
It's not like you have to wait for their decision or response.
Okay.
It's just like filing, sir.
Okay, it's like a memo being
yeah, it's like a memo only.
Thank you, sir.
By the way, Mr. Jayagopal, you are from which part of the country?
Bangalore.
Bangalore. Oh, very good, sir. Okay, very good.
Thank you.
Do you see many liquidation cases there in Bangalore NCLT?
Yes, that is true, sir. Yes.
Oh, okay.
So we have some other liquidators. We interact with each other to learn more.
Okay. A lot of cases are going under liquidation, but unfortunately, the process time is huge. Delayed by various factors.
Yes.
Even some of the liquidation matters handled gets into litigation aspects. There it goes into a long, period of.
Very true, sir. In my case, it has taken more than 2 years because it went to NCLAT.
Okay.
So this is how the situation is.
Okay, I'm probably one step ahead of you. We have cases more than 3 years.
Oh, then I can learn more from you now.
Or even 4 years also sometimes. 1 or 2 cases are there. Okay, various reasons could be attributed for such delays. So this is on the second proposal. If there is any comment, please come out. Otherwise, we will go on to the next point.
Rajendran sir, can I request on proposal 1? There are 2 parts of it. First is regarding the interim SEC, which will discharge the functions with, within the 60 days period. when the SEC is formed on the liquidation commencement date. So what is the final opinion on that? And second is the second part of that first proposal. So
frankly, Nitin, the opinion shared by one of our participants, Mr. Nageshwaran, is that the liquidation value, what they are talking about, there are two different kind of a thing. One is the valuation arrived at during the CARP process, and the other one is there is a kind of a flexibility being brought in this suggestion paper. Wherever the SEC desires to have a fresh valuation, you can go for a fresh valuation. So this basis of taking the stakeholders committee on the basis of the liquidation value, which will be receivable by the stakeholders. I think this is a little bit complicated kind of a situation it is introduced. So I am not able to get other members' views, on this particular point. Maybe please give us some time during the course of the discussions if some other view comes up. Otherwise, right now there is a complication in this second limb of the proposal 1.
Okay, sir.
Okay, so relinquishment, I think point number 3, relinquishment of security interest by secured financial creditors. Okay, so can you show this proposal? Okay, just highlight this proposal. So it's a pretty simple kind of a thing. I think the claim form, when the liquidator calls for submission of claims, a secured creditor, when he submits the form, he has to mention there in the form itself whether he is going to relinquish the security interest or not. And the time given to him was 30 days because the form itself has to be submitted within 30 days of the LCD commencement date. Now, the proposed amendment says you don't take so much of time to decide whether I am going to relinquish or retain the asset. You decide within 7 days of the commencement, or you please inform in the first meeting of the stakeholders committee. The first meeting happens as we had seen earlier. The first SEC meeting has to be convened within 7 days of the commencement date. So there is a kind of an urgency which has been brought in by this amendment that within 7 days, you might not even have submitted the claim form because the time given for you is 30 days, but the meeting happens within 7 days. So even before you submit your claim, you please clarify and confirm whether you are going to retain the security interest or you are going to relinquish that. I think this is a good effort. It's a good kind of a suggestion and step taken in order to speed up the process. I feel like if some of the participants, if there is a lender, any banker in the participant today, any of the bankers, because they are the class of people, secured creditors, who have to take a call on that. Or I can even request some of the ex-bankers in this forum who are also insolvency professionals. Do we have Mr. Venkatraman here in the participant list? Sudhir? Yes, sir. Sir, Mr. Venkatraman, are you there? Okay. Any other, sir, Mr. Nageshwaran, you can also speak on this point if you have any comment on this, or any other member, please.
Actually, I have got an idea the same way. Now, if suppose the liquidation value arrived at earlier, mainly on, say, let us take that there are only 2 financial creditors or 1 creditor who is holding the entire security.
Okay.
The liquidation value has been arrived at based on that security majorly. Now he is also kept out. Now, the liquidation value will also be adjusted to that extent before arriving at the remaining members' voting share. If that way it is going to be done, what will be the voting share and what basis on which it can be done? Because the liquidation value will undergo a 100% change, because maybe that is the only security and that person is going to keep out of the SEC. Now, who is going to be the SEC?
Okay. Yeah, I think that's a practical kind of a question before the liquidator. You know, if the secured creditor wants to opt out along with the security, what is the value which he will realize and he will keep it for his claim, admitted claim, and the remaining amount, if at all anything is there, only will come to the liquidation estate.
Yeah.
I think that's a good point. I think in many of the cases it happens, and also where same security is shared by two creditors, then the problem is still more complicated. That is a pari passu charge.
Exactly. And one withdraws and says he is not relinquishing, the other says he is relinquishing. What will happen?
Okay.
And the security is one.
I think this particular point on relinquishing, on one side, it aims at speeding up the process.
Yes.
But I think I'm afraid, the complexities of addressing what will happen to the liquidation process per se, I think there we are getting onto a kind of a difficulty in resolving this liquidation process. Okay, I think, sir, if I run through this comment, the proposal, a secured creditor shall intimate its decision regarding realization or relinquishment of security interest under Section 52 of the Code in the first meeting itself, instead of currently mandated 30 days from LCD, where a secured creditor does not intimate its decision in the first meeting, the assets covered under the security interest shall be deemed to be part of the liquidation estate. I think this provision is already there
Yes.
in regulation 21A or somewhere it is there.
It is there, sir, already.
Already there is a provision.
The same 52 itself is there.
Yeah. I think it is in 21A proviso, where a secured creditor does not intimate its decision within 30 days from the liquidation commencement date, the assets covered under the security interest shall be presumed to be part of liquidation estate. So now, instead of this 30 days kind of a thing, now they would like to make it as a 7-day timelines. Further, if a secured creditor decides not to relinquish its security interest, such creditor shall not be part of SEC, and the voting share of the remaining members of the SEC. I think this is where Mr. Nageshwaran was saying, if that guy takes away the security and he will not be forming part of the SEC, and the voting share of the remaining members of the SEC shall be modified accordingly. So we need to see, is there any asset going to be there, remaining assets going to be there, and who are all the people fighting for a part of that remaining asset, and that will be forming part of the voting share of the remaining members of SEC. It looks like probably the major portion of the assets and the major portion of the creditors will go away, and only the remaining chunk of people, the operational creditors, if at all they are going to get something, they will be there in the SEC. Otherwise, SEC, I'm afraid, will not have any people to sit there, any people to participate because of the particular stipulation in the proposal number 1, where it links the amount to be received by them in the liquidation process under Section 53. Okay.
Yeah.
You have any comment on this, Nitin? Because this is, again, it goes back to the suggestion number 1. Voting share.
Sir, in a way, it is correct. I mean, sale as a going concern, and always efforts have to be made that the plant and machinery and land building are sold as one asset. Yeah. But sir, okay, in one of the cases that I myself faced was in my first organization, we were working for Ministry of Science and Technology. Then a company was there of whose plant and machinery we had financed, and 8 crore loan was given, and so plant and machinery were hypothecated with us. The land and building was with PNB. So we were always insisting that if you take away the plant and machinery from that from that place, then the plant and machinery would not be able to get us anything. So there was at that time there was a judgment of Supreme Court, Allahabad Bank versus Canara Bank, wherein it was said that the secured creditor cannot be pressurized to go for a joint sale. So similarly, sir, if there's a secured creditor, so we cannot beyond a point ask him to come up for a joint sale or help us with the sale as a going concern.
Yeah.
So secured creditor would always have retain his right.
Correct. I think there is some stalemate kind of a situation is quite possible by pushing the secured creditors to give only 7 days. I think in most of the cases, the secured creditors would not like to relinquish their security interest. They would like to cling on to their at least whatever is available. That will only in many of the cases, even the cases which I am handling in the liquidation process, the banks are not willing to relinquish their security interest, whatever be the amount. So implementation aspect or the a timeline of 7 days, maybe a decision need to be taken by the secured creditors. They will immediately say that, sorry, I'm not going to relinquish, because 7 days you are saying we are not inclined to relinquish the security interest. If there is a pressure, is there any pressure on the secured creditor to realize its security interest and appropriate the money and pay if there is anything balanced to the liquidator? I think a lot of litigations are going on. I'm on a case where a state undertaking, state lender, state industrial investment corporation is not able to sell the assets. They are not relinquishing. They are not able to sell. 2 years have gone, and the asset is still getting eroded. The value is just going down and down. So these are all some of in spite of section, in spite of regulation 21A. 21A was brought only to ensure that the secured lenders play their game properly, play their game in a manner appropriate without unduly delaying the process. Okay. So yet again, Mr. Nitin, unless some of the other members, I don't know if Deepa has come back or Mr. Venkatraman has joined back.
I am here.
Sorry.
One small question once again, whether I'm on or not. Yeah, I have one small point here. The financial creditor, say, for example, big banks like State Bank of India, they don't come back within 7 days. They seek more time. So when you stipulate within 7 days, we have to hold the stakeholders committee meeting, it becomes a real challenge, because I experienced with smaller banks itself. So though I wanted to hold the meeting in the bank premises itself, so it's easier for them to attend. They didn't. So I don't know how we can address this problem.
Okay. Yeah, sir, I think that aspect of, the COC members, I think a lot of things have been talked about it, like code of conduct or standard of conduct.
Yes, sir.
A lot of things are there. I think let's not get into that right now. Let's wish that, as I told you, Mr. Venkatraman, that, within 7 days, if some decision has to be taken, the decision is already taken. I'm not going to relinquish. I think most of the cases, it may go that way. Let's see, sir. And if I may, due to time constraints, I will now go to the point number 4, proposal number 4, which is also a quick one. That
Sir, just a second. Sir, I mean, just drawing a parallel with the CIP proceedings. So if a company is to be resolved, it has to be done within a particular period. Otherwise, the natural consequences that the company goes for liquidation. In a similar fashion, if somebody wants to realize their security interest over an asset, that has to be done within 7 days. Otherwise, the assumption is that you have waived off your right. So is it not all right?
No, perfectly all right as per this, the provision. But in reality, the creditors are before the adjudicating authority that please grant me some more time to realize the asset. Otherwise, I will be, in kind of a fix. For example, I will not take more time, Mr. Nitin, for the benefit of the group. See, there is a proposal, there is a kind of a provision. I think it is regulation 37 of liquidation process regulation, where the methodology of the secured lender, how he will realize the security interest. I think it is regulation 37. that he has to inform the price at which he will dispose it off. He will inform the liquidator. Liquidator will check whether that price is okay, or if liquidator is able to get a better price, then he will dispose the asset at the better price. All these things will be there. And finally, there will be a provision that all these provisions shall not apply if the secured creditor enforces his security interest under SURFACE Act or RDBA Act, which means he need not be bound by all these requirements to the liquidator. He will simply go ahead and then say that I am under SURFACE Act. I will realize the asset. I will come back to you. Okay. Now, contesting this 37 is 21A. 21A puts a specific timeline of 180 days plus 180 days. There are two provisions of 180 days in the, am I right? 21A. Where the secured creditor has to realize this security interest 90 plus 90. Actually,
90 plus 90.
90 plus 90. Actually, 90 days, if he is not able to realize, then he has to pay the money, which, it has to be payable for the workmen and employees share that they have to pay. And even if 180 days he is not able to realize the asset and pay the money, the asset comes back to the liquidation estate. Okay, so all these provisions are there, Nitin, but in reality, it's not happening. It's not happening. Probably, I think, this time the amendment is clearly saying that it will become forming part of the liquidation estate, but it might be definitely contested because the secured lenders are sitting on only that particular security. And the complexity here is on the remaining people, how much they will get and their share, voting share in the SEC. I think there's a little bit complication is there in that. Okay, moving on to the proposal number 4, I think I can quickly run over it because it is empowering the stakeholders during the liquidation process that they can, by a vote of not less than 66%. I would like to highlight to the members that it is not like a COC CARP process here. The voting percentage is present and voting, the people, number of people present and voting, and not with reference to the admitted claim value. It is the number of people, number of heads in the SEC. I don't think it has been modified. So by a majority vote of not less than 66% present voting, propose replacement of the liquidator, and it shall file an application before the adjudicating authority for appointment of the proposed liquidator. I think the need for this amendment was that unlike in the CARP process, the liquidator cannot be changed during the course of the liquidation. It was felt in many cases. I think even the adjudicating authorities have felt that need. Where is the provision for change of the liquidator mid-course? So I think this is, the power has been given to the stakeholders to change the liquidator during the process of the liquidation. I think now another important thing is the fixing of the fees of the liquidator. This is proposal number 5. I think there is a paragraph of, a comment has been given as to what happens to the fees of the liquidator. I think it's a very interesting thing on the liquidator fee. So many things are happening on liquidator fee. A kind of an enticing table in rule, regulation 4 in liquidation process gives you certain percentage of, payment for a liquidator. I think most of the cases the people are, looking at this kind of a realization. It starts with 5% and 2.5%, and then goes down as the period goes up. That is the kind of a provision for the liquidator fees. I think in the same regulation 4, it will also say the COC is entitled to fix the liquidator fee. And another aspect of the liquidator fee comes under CARP itself. I think it is 39C, 39D. There was another requirement during the CARP process itself. The committee has to discuss what will be the kind of fee for the liquidator, 39D, regulation 39D. So during the process of section 230, how much he will get, during the process subsequently to that, how much he will get, and the balance period of liquidation, how much the fee should be paid. All these things have been talked about it. I think now the lawmakers or IBBI also has come to the view that all these things would not be appropriate, because between the CARP ending and the liquidation order coming itself, there is a huge time lapse. So the fee which might have been thought about it by the COC may not be relevant now. So accordingly, the need for fixing or reviewing the fees of the liquidator has been felt, and so the power of deciding or reviewing the fees is now given to the stakeholders consultation committee. But if you really look at it, Mr. Venkatraman Jayagopal was telling, when nobody is there in the SEC, whether the fixing of the fees, how it will get determined is a question. And the amendment for this fixing of the fees, I think the corresponding amendment in the regulation talks about only review. So I think it goes to the regulation 31A, Stakeholders Consultation Committee. So in the regulation 31A, they are adding as a part 3, part C, clause C. What it generally talks about is to advise liquidator on matters relating to remuneration of professionals appointed under Regulation 7, sale under Regulation 32, including manner, etc., and review fees of the liquidator. Now, the question is, some of the members might like to definitely respond to me, my question. Review the fees of the liquidator, does it mean the power to decide the fees? Any opinion from the learned members here? I saw some names of participants. There are about how many participants are here? 57. Any participant, I request, just share your views on.
Sir, my view here is, if stakeholders committee is going to review the fees of liquidator, which means that the CARP process itself under section 33(1), the fee has been finalized when the company is recommended to go for liquidation. So the same people are going to come and sit here, maybe with lesser number of people in the SEC. So why it has to be reviewed when the CARP processes on section 33(1), COC has recommended the appointment of liquidator along with the fees. So why the review is required to be done at this stage after the liquidation order is received?
See, possibly one thing, Mr. Venkatraman, is that this particular amendment of the role of the stakeholders committee has been highlighted here is on matters relating to remuneration of professionals and the process and review of fees. In case the SEC is not happy with one particular liquidator and they want to replace him with another person, then during that process, the fees again has to be determined. So for the next person incumbent, also the SEC can fix the fees. So the wordings here is, the wordings here are slightly kind of, makes it a little fluid. For example, you see, to advise him on matters relating to remuneration. See, the advice can be given to the liquidator on matters relating to certain extraneous things or external things. For example, what the liquidator does is to appoint professionals and their remuneration, sale process. But it comes to again fixing my own fees to advise the liquidator on fees of the liquidator. So probably I think there is a kind of a need for a slightly better wording of this particular clause. Whether it is an advisory role and then or a kind of a deciding kind of a power is given to the SEC. But if you really look at the comments prior to the proposal, it looks like the SEC is empowered with certain rights to replace the liquidator, to fix the fees. Would you agree with me, sir?
Sir, yeah, the narrative was very appropriate. I have only one question. See, the SEC is going to only advise the liquidator to review the fee, I mean, to modify the fees or increase the fees. Or whatever is the decision. But it is not binding on the liquidator to accept it. He can always prevail upon his own decision and file a memo with the adjudicating authority. Will it work? Whether my narrative on this, my understanding of the situation, is it appropriate? Correct?
Sir, he cannot fix his own fees. Can a liquidator fix his own fees?
So it's not possible.
Nageshwaran sir, yeah, please tell me, sir.
Yeah, see, one more thing, and that is, now if as during the last meeting of the COC, when they decided on the liquidation to be, recommend for liquidation, they have decided the fees, they have done everything, and this has been approved by the NCLT. When a NCLT approved matter, should it be opened? Should it be opened by a SEC again? And that too, as we have been going through the various proposals so far, the SEC is getting thinner and thinner, and finally it could become a member or somebody who is going to be saying that, okay, this liquidator is not comfortable for me, I will bring my own liquidator, and that liquidator will get through the entire process and complete the liquidation. If this is going to be the access part, then on the NCLT approved liquidation orders where the fees, everything has been fixed, is it possible that an NCLT approved order can be challenged or changed by a SEC member?
Good question. Yeah, good question. Is it because the word review has been made? Review the fees, advice?
No, as Mr. Jayagopal Venkatraman told, it is already put up to NCLT, and the NCLT has approved the liquidation suggestion by the COC and put their stamp. And that means that they have put the stamp for all the matters related to that liquidation proposal.
Okay.
Including the fees for the liquidator.
Okay.
If it had been put there.
Sir, but one kind of a thing for me, see, all these 39D, we are talking about 39D. So those things might be when a resolution plan was put up for approval, no?
No, that is why when resolution plan was put up for approval, in case the adjudicating authority is not going to approve the resolution plan, then it should also be decided. That is what your 39B, C, D, all those things says. These are all compulsory because in case the adjudicating authority decides not to approve the resolution plan, what has been suggested to them, they will go for a liquidation. And if they order liquidation, then automatically all these things will take place, no?
But my understanding,
that is automatic, no?
Yeah, but my understanding, sir, wherever resolution plan applications have been filed, how many of such applications, instead of passing the resolution plan, liquidation might have been ordered? I think it's very less. I think 10 numbers or something. I saw that IBBI news bulletin where non-compliance of the code, a resolution plan application has been turned down and the liquidation has been ordered. I think, sir, it is a very less number of cases, but
it is true.
Nevertheless, sir, nevertheless, the point highlighted is wherever there is a provision for liquidator fees already decided or already worked upon, regulation 4 is also there. So where is a need for reviewing of the fees?
Exactly.
So it looks like to me that whenever there is a change of liquidator, probably the SEC can again talk about the fees. And nowadays I'm seeing the liquidator fees are also being negotiated very hard, and then it's all being discussed. Why so much of money has to be paid for a liquidator. Wherever the assets are in huge value, in those cases, such kind of a thinking process is coming up. So anyway, I have some interesting people on the platform. Dr. Ahlad Rao is there. Sir, can you hear me, Mr. Ahlad Rao? Fine. So in this point of the liquidator fee, the provision or the amendment which says that SEC can do that review or fixing, probably, it has to be applied on a case-to-case basis, whether the SEC would like to go to the review mode on a need-based kind of a thing, it may happen. But the wordings again, Mr. Nitin, in case, if somebody is taking note of this thing, the wordings of the amendment probably advise the liquidator on his fees. Okay, it might be possible for a negotiation with the liquidator to fix the fees for the particular assignment in the committee itself, in the stakeholders committee itself, they can come to a conclusion. I think that is an enabling provision. Okay, sir, let me move on quickly. Compromise or arrangement, I think there is a provision which says that the number of days available for Section 230 under Companies Act should be reduced to only 30 days rather than the 90 days from liquidation commencement date. So you can just go to the proposal number 6. Now, I think this is a good point where there is a gap between COC approving the liquidation and NCLT passing the liquidation order. There is a gap. Normally, it takes about on the lower side maybe about 2 months or 3 months, and in many cases it takes much longer time. So the proposal is that in case COC decides during CRP process to explore the process under Section 230 of Companies Act, the liquidator shall complete such process within 30 days from the liquidation commencement date. Regulation 39C of CARP regulations will be suitably amended in this regard. So I think this is a point where the judiciary's time-taking process, we cannot do much about it. It's a mandatory or statutory or directory kind of timelines, but at least within the limitation of the time lapse happening at the judicial process, whether the RP can take an action even before a liquidation order comes, even before the NCLT orders liquidation. Can the RP start the process because COC has decided that let's go for liquidation? Am I saying it right, sir? I think in this provision,
Yeah.
If I may check with some of the members here, I think Mr. Nageshwaran, this is a case where to compensate for the delay in the judicial process,
Exactly.
whether the RP can initiate the Section 230 process in order that as soon as the NCLT order comes for liquidation, he will be able to immediately place it before the stakeholders committee, which will be there in 7 days, the meeting, and the proposal for Section 230 can be pushed to the adjudicating authority. I think that's why they are saying 30 days time. It seems to be okay. Am I right? This suggestion, I think.
Yeah, it appears like that.
Yeah, it takes an in between period, instead of keeping it quiet, the process continues.
Sir, I think this is possible, sir. I think you just called me. I'm sorry, I'm not in a position to talk with you.
Hello, sir. Hello. Good afternoon, sir. How are you, sir?
Fine, thank you, sir. So, yeah. And coming to, I think you want my opinion on this matter only. If that is the case, whatever you told, when those COC has recommended, liquidate RP can opt for this 230 in the while the process is on. Also, this is what it is possible, sir. Actually.
Okay, good, sir. Good. Thank you, Dr. Ahlad. Thank you.
Thank you.
Now, an important aspect I think Mr. Nageshwaran mentioned about it earlier is on the valuation. This is proposal number 7. There, I think we also spoke earlier that because of the time lapse, the valuation done during the CRP process becomes outdated, irrelevant. So when it comes to liquidation, should we go for one more round of valuation? There was a question in the provisions whether liquidator should go for a fresh round of valuation. As a clarification, it has been proposed now that the liquidator shall consider valuation report as arrived at during the CRP for conducting auction. However, where the liquidator is of the opinion that fresh valuation is required, we shall seek advice from SEC, and such valuation may be considered for subsequent auctions. So this is a kind of an enabling provision that the SEC can ask the liquidator that you please go for a fresh round of valuation, and from there you take the reserve price. I think for auction they need to have a reserve price. So arrived at exactly, that is a reserve price requirement. For that purpose only we need to have the valuation. So if you just go to the previous paragraph, Jyoti, one more paragraph. So it is still imperative that an option to conduct fresh valuation with the approval of SEC be provided to the liquidator. We is of the opinion that fresh valuation is required for ascertaining correct picture of value of the liquidation estate. However, such an option for appointing valuer should be available without any specific timeline to provide requisite flexibility to liquidator to get valuation done anytime during the process. It is opposite. It is opposite to mention, it is appropriate to mention that such determination of fresh valuation should not delay the auction process. Okay, I think this is left to the discretion of the SEC to decide. So at any point of time during the liquidation process, if it is required, then a liquidator can go for a fresh valuation, of course, with the consent of the SEC. Okay, so this is the one another important thing, and the other aspects, just can you please proposal 8. This is the liquidation regulations may be amended to provide that the liquidator shall submit copy of progress reports. I think I spoke about it as the additional kind of steps taken. So I think this is a requirement of the reports to be submitted along with the adjudicating authority. It should go to the IBBI. I think IBBI will now give a kind of a format for the filing of the process, and for which the circular is awaited. Okay, fine, this is okay. Then the next item, proposal number 9, is for timelines for auction. I think it's a welcome move. Members may give me any suggestion, any comment on this proposal number 9, where you can see the kind of timelines. The public notice for auction, e-auction, including availability of process memorandum and other documentation. Yeah, we are just getting some network, some slow is there. Okay, submission of eligibility documents by prospective bidders. I think a minimum of 14 days time has to be given for the auction process. Then declaration of qualified bidder by the liquidator. It takes only about 1 to 3 days. Data room access, site visit, discussion, meeting, all those things minimum 7 days. So submission of earnest money deposit 2 days. Overall, the process of auction should take only 35 days. So this is the kind of the timelines which have been stipulated in the discussion paper. And I'm sure, sir, in today's context, the liquidators are taking different kinds of timelines for various processes. Like CARP, we have a different timelines for IEM, RFRP, and then expression of interest, resolution plan. In a similar manner for liquidation auction process also, these timelines have been introduced. So I think this is a good step, good measure, and it will also bring some kind of discipline, a kind of a uniformity in the liquidation process. I think in the same breath, in the same proposal, this is a minimum threshold, and with the freedom to the liquidator in consultation with, I think in para 28 you can see, in consultation with SEC to provide additional time for any event except submission of bids which is mandated on 35th day on the facts and circumstances of the case. So I think this entire table is going to be now brought into the amendment and the regulations. Also, there is a kind of, go to paragraph 29. The first auction notice for sale of corporate debtor as a going concern may be issued within 45 days from the LCD, subject to the process of compromise or arrangement under regulation 2B, that is section 230, being not pending. So if the first auction notice has been issued for sale as a going concern, it is proposed that the second auction shall also include possibility of selling the assets in other manner, though it may give an option of selling CD as a going concern as well. So yet again, the suggestion, the proposal talks about being a time-bound auction process, disposal process should be followed. Otherwise, it will take its own course of action. So here, the amendment has been brought in, I think by way of the amendment has come. Yeah, in subject to regulation 2B. Oh, it's all going in schedule 1. After the clause following shall be inserted, namely subject to, you go to the, you can see the paragraph 44, which paragraph? I think it's in the amendment page. So all these timelines have been brought into the regulations by way of, the proposed amendment that the liquidator shall issue public notice for an auction sale under regulation 32 within 45 days. I think from there, commencing from that, I think from 1B, no. So this is the amendment which has been proposed for the timelines to be brought. Okay. Now we will move on to item proposal 10. It is proposed that in the in the event of failure of an auction, the successive auction notice shall be issued within the next 15 days of a failed auction, while following the foregoing event-based timelines, unless the SEC agrees to extension of this timeline on specific grounds. So here again, the idea which has been proposed is that there should not be any further time loss. So within the next 15 days, sometimes it may take even a longer period for the next auction to come. But the regulations now provide that within 15 days, let us do it. As a continuation of this proposal, any comment on this proposal 10, please interrupt me. Otherwise, let me just run through it. Proposal 11, liquidation regulations may provide that auction platforms of PDAs, platform for distressed assets, as empaneled from time to time, may be exclusively designated for offering auction services. So I think the regulations also have been proposed to be amended, providing for such platform. Okay, I think otherwise people go to various auction services like Auction Tiger or bank auction or bank assets. So there will be uniformity, and people will be able to see in one particular platform. Any comment on this from the members? Okay, I think we are coming to the last leg. Proposal 12. I think this also we spoke about it. Liquidator shall use the information provided in IEM and valuation conducted during CRP for preparation of asset memorandum and submit the same to adjudicating authority within 30 days. Liquidator shall share the asset memorandum with the SEC after receiving confidentiality undertaking from the members of SEC. I think this is definitely a progressive kind of a step that SEC or COC should be in a position to know what are all the assets, and there should not be any problem in sharing it. So I think this is a welcome kind of a thing. Any comment on this proposal number 12?
No, sir.
I think as lenders, ex-bankers becoming insolvency professionals, definitely they would appreciate that more information in the hands of the COC. It is for them to take some informed decisions during the liquidation process. This is 12. Item number 13, proposal treatment of. I'll quickly run through this 13. Oh, sorry, 13 is what? Interim finance availed during CRP period. No, it is interim finance for liquidation process, more than 1 year interest was not permissible, right? Am I right? The code provides that a resolution professional during CRP may raise interim finance, and such interim finance shall form part of the insolvency resolution cost. The liquidation regulations provide that interest on interim finance for a period of 12 months or for the period from the liquidation commencement date till repayment of interim finance, whichever is lower.
So, sir, the proposal is, for example, as of now, whatever the interest is payable on interim finance, at present it is only payable for the 12 months period, or in case a liquidation is concluded before 12 months, so for that period. Now, what they're saying is, because interim finance is a need of the hour for a company which is in liquidation. So, for the entire period of liquidation, I mean, the interest on interim finance will be payable.
Nitin, I think at the time of defining the liquidation process cost, in that I think the provision says, I think it's a definition 2 EA, interest on interim finance for a period of 12 months or for the period from LCD till repayment of interim finance, whichever is lower. Yeah, correct, I think. So essentially they had wanted, the lawmakers wanted to limit the interest for only 1 year. Idea could be, the liquidation period earlier was 2 years. Now it was reduced to 1 year. So why we should allow interest payment beyond 1 year? But I think by seeing the time lapse which is happening, I think this cap has been removed now. So what is it they are now proposing? The liquidation cost shall include interest on interim finance till the same is repaid. That means, the cap or timeline is removed now.
Irrespective of the timeline, sir.
Irrespective of the timelines, yeah. I think it's good.
Liquidation is going on extension by the NCLT. So quite reasonable proposal. This is reasonable actually.
Otherwise, the people, who are coming forward to give interim finance, they would not be, sure of getting more interest, getting the appropriate interest. There will be somewhere stoppage after 1 year. So I think in my interaction with some of the people in this field, because recently we were in the market for raising some interim finance for a company under CRP, a lot of questions were asked, whether you will be able to find a resolution plan, when you will get approval, if not, what will happen in the liquidation, what will happen. So even before, they talk about the term sheet, all these things, come up. And at the time, they were also referring to this provision, I will not be able to get interest for more than 1 year. So they all stack up all these things in their interest rate. And normally the interest rate is upside of, 18, 20, 22%. So it's a good measure, definitely.
It's a good measure, sir. Slight deviation. Whether they mentioned any objective means the purpose of interim finance is only for going concern basis or operations or anything part and parcel of liquidation. It is okay. I didn't find any express provision or regulation for that.
I don't think any purpose. Maybe, sir. I think it is captured in the code, where the duties of the resolution professional, it talks about the raising interim finances subject to the approval of the Committee of Section 28. And also, if you read, the code again, management of affairs of the corporate debtor management of operations of CD as a going concern. So section 20, where it talks about IRP shall have the authority to raise interim finance, in that context, it is talking about security and all. So the very, the purpose of interim finance is captured in section 20, which talks about the, keeping the company as a going concern, managing the corporate debtor as a going concern.
Because during IRP, RP period, there is every possibility of going concern. But when it is come to liquidation, Still going concern concept is there, but practically so many companies will be closed. So that is the reason I just posed this question. Whether object and purpose of interim finance is just to manage the show as a going concern, or otherwise also liquidator is having power to raise interim finance. Slight deviation to our discussion. That's all. Sorry.
Sir, regarding your question whether a liquidator can raise finance, interim finance is a definitely a question mark. I don't remember to have read whether a liquidator is having the powers to raise interim finance, but it is all only the interim finance raised during the CRP period and still unpaid and coming during the liquidation process, and the interest also is coming out of that outstanding. Please correct me if I am wrong, Mr. Nagesh or Mr. Venkatraman. Because I think
your view is right, sir. Because I have not come across cases where a liquidator is able to release funds during the liquidation process.
Yeah, that is true, sir. It is not given. It's only the resolution professional or IRP who has been given the right to raise the interim finance.
Raising of finance.
Raising of interim finance is only for that. Actually, as the changes go ahead now, because even during liquidation, the company is being asked to be kept as a going concern if possible, if it was going through, like 1 or 2 cases which we are handling now. It is true. It could be a situation where the company will be running as usual as it was running through the CARP. And liquidation has been announced and it is going through the liquidation process. But the company is having the staff and having the source of income even today also.
Good. Thank you, Mr. Nageshwaran. Sir, I think we are now into the last one, last but 114. It's an important kind of proposal, treatment of avoidance applications. So I think the essence of it is that before the SEC goes for the last meeting to dissolve the company, if there is any avoidance applications pending or yet to be decided by the adjudicating authority, I think the SEC should put on record, should decide the manner in which such proceedings in respect of avoidance transactions or fraudulent, wrongful trading will be pursued. Who will pursue, who will fund it, all those things should be specified after the closure of the liquidation process, and the manner in which the proceeds, if any, from such proceedings shall be distributed. Who will be beneficiary, if at all, anything comes out of such process. This decision shall be part of the final report filed before the AA. I think basically this provides for a continuation, a provision, which has to be made in the SEC decision. And so because some of the avoidance applications may run much later after the company has been dissolved, because it is an independent process, maybe from the promoters or from the other people who are involved in the wrongful gain or fraudulent transactions. So it's a welcome move. Any comment on this?
This is a good move, sir, because otherwise normally it is being taken up that avoidance application anyway will come to a natural death once the dissolution happens.
Yeah.
On that, many people bank the avoidance application anyway will come to a closure once when the dissolution happens. So on that in that process, people just leave it open.
Because
so
it
now,
is sorry, sir.
Now it is already, now it is being taken to the that resolution is not the final nail on the avoidance application.
Correct. Sir, one question.
I have a point here.
Yeah.
After the company is dissolved during the liquidation, at the end of liquidation process, and then if there are some avoidance of fraudulent transactions, cases filed with the NCLT, and if we are able to recover the money, how that money will be distributed, whether any committee will be formed, some sort of regulation is required, I think, at that point of time.
Sir, exactly. I think this is what is stated here. Can I take you through the amendment?
Sure, sir.
Yeah, go to the amendment, sir. 44A is the regulation which will be proposed to be inserted into that. The liquidator shall, in the application filed under the sub-regulation 3 of 45, provide for the manner in which proceedings in respect of avoidance transactions, if any, under Chapter 3, or fraudulent or wrongful trading under Chapter 6 will be pursued after the dissolution or closure
Okay, yes.
process, and the manner in which the proceeds, if any, from such proceedings shall be distributed. My colleague also is asking me a doubt whether any such realization should again be routed through the waterfall mechanism of Section 53. I think that is a liberty given to the SEC. The SEC will say, because it is not a kind of a money for sure it is coming. We don't know whether the money will come or not. And you are also supposed to spend for litigation, isn't it? You have to engage some counsel, appear before the NCLT,
Yes.
hearing after hearing. Even in one case I am handling, it was a resolution plan approval. It's more than 2 years now. Plan is approved, everything is going on, but the avoidance transaction is still being continued, no end in sight. But fortunately, the financial creditors were the beneficiaries for any such clawback amount, and so they are paying for the legal fees and all, and they are supposed to be the beneficiaries in the, but that is in a resolution process. But in a liquidation process, what is that? We don't know. It is the SEC's discretion. SEC should apply their mind and they should say, they should decide. I hope, sir, I think if there is any further kind of, actual in practical experience comes, then this will also undergo some change. Probably one clause may be there, that subject to the provisions of Section 53. Probably it may come. Yeah. So as and when the money comes, again, some portion may go to probably the secured lender only it will go, because anything under liquidation process, the top cream would go to the CARP or liquidation cost, right? The balance comes to secured lenders. Correct. Okay. So we are all talking about as if some big money is going to come, which is not the case, I think. Absolutely, sir. So that takes us to the last one, sir, is point number 15. I think this is an enabling provision which says that, people who have not submitted their claims, they have slept during the liquidation process, but still the law provides that, gentlemen, wake up. Anyway, I'm taking your claim in the liquidation process. I don't know whether it's a good law, the law providing support to the person who is sleeping, but still I think the intent of the law is that people should not be left out of the liquidation process, because it is the last nail on the coffins of the company. I think what is the proposal? The liquidator shall consider liquidator shall consider the claims collated during the CARP in respect of claimant who have not submitted their claim during liquidation. Okay, so it doesn't speak about any particular claimant in general. Okay, I have a case where a financial creditor has not given his claim during liquidation process. He had given it in CARP. Now, as per this provision, the word used is liquidator shall. How is it appearing in the amendment? Page number 11. Okay, last line. No? In the principal regulation, in regulation 12, the following shall be inserted, provided the liquidator shall consider any claim collated during CARP but not submitted during the liquidation process. So the assumption is that there won't be any change in the amount between CARP to liquidation commencement. Okay. But Raghu, I think there is always some kind of a possibility. If CARP process, the company is as a going concern, it is there. Okay. It is considered as a going concern and you make some payment and all. Okay. The amount prior to CARP will remain same because that will not be settled. During the CARP period, any amount payable will be paid if it is a going concern. Okay. Okay. Okay, it makes sense. We'll have to see whether how it works. I think it is going to be a beneficiary thing by reducing the number of claims. People will come and say that I submitted my claim. Now you please, why you have left out me in the liquidation? You have to take it. I think the liquidator will now have to do a little more work, compare the claims in CRP process, claims in liquidation process, how much that guy has given earlier, how much he has given now, and whether somebody has completely not given, please include him. So another category of claimants might be there in the process. Okay, sir, good. I think any comment on this? Otherwise, we'll move on to the another important aspect, I think, for which we have a small little time only is available, but still it's a very important thing. Okay, ladies and gentlemen, we now go to the second part of the discussion paper, which is a very
Rajendran sir, can I take just 1 minute? Actually, regarding that completion of 230 section 230 proceedings within 30 days, so I was going to the language of it. So is it any way possible to complete within 30 days? So the language of the law says where okay, I'm reading from the third point. It says in the principal regulations in regulation 2B. For sub-regulation 1, the following sub-regulations shall be substituted, namely. Now it reads as where under regulation 39C of the IBBI CIRP regulations, a compromise or arrangement is proposed under section 230 of Companies Act. It shall be completed within 30 days of the order of liquidation under section 33. So it is not saying it will be initiated, but it is saying it has to be completed within 30 days.
Yeah, this completion aspect, Mr. Nitin, I think it is to the extent of putting it to the adjudicating authority. Beyond that, you cannot have you don't have the what do you call the ability to complete it. It is not in our hands to complete it. Okay, the language part of it, I think even before it was there, I think it should be completed within 90 days.
Same only.
Yeah, even before it was there, amendment also. But it is a good point, Nitin. If you really look at how many cases of section 230 have been handled, I think you go to IBBI.
So it says it says only 7 or 8.
Exactly. Recently, we had 1 or 2 cases. I think slowly it is catching up.
And if I remember, the average number of days was crossing some 453 days or something.
Yeah, correct. The liquidation process, sir?
Yeah, and that 230.
Under 230 also.
230 itself, it was 450 days, average number of days.
Oh, from the beginning stage till NCLT order.
Yes.
Yeah, you are right. You are right. Absolutely, you are right.
It was there in the IBBI paper, if I remember right.
466 days, correct.
Yeah.
And the liquidator has realized only 87%. Yes, Nitin, the language part of it here shall be completed within 30 days is a tall order. I think liquidators shall strive to complete probably a better wording.
Or should it be, it shall be initiated or some?
Shall be initiated, yeah.
Okay, sir.
Okay, that's a good point. Okay, so can we move on to the second leg of our discussion paper, which is on enabling entities to become insolvency professional. Okay, I think the context, as we had said sometime earlier at the time of beginning the session, insolvency professional is now only individuals. And by virtue of the definition of a person, now the thought process has evolved that why not the insolvency professional role be played by other than an individual or a collective, part of a collection of persons or people, insolvency professionals coming together in a kind of a form recognized by law. So if you see the definition of a person, about 7 cases of definitions have been given in section 3, subsection clause 23. So in that you can see individual, HUF, a company, trust, partnership, limited liability partnership, and any other entity established under a statute. So now the proposal initiated is whether the insolvency professional role can be played by a company, a limited liability partnership, or a registered partnership firm. I think these three more kind of this thing. I think it is almost similar to an IPE. Insolvency professional entity was allowed to be formed in these three forms: a company, a registered partnership, or a limited liability partnership. So taking a cue from there, and also going by certain developments in the valuation profession, where apart from individuals, valuation is now done by even entities, which contains experts in different classes of assets, land and building, plant and machinery, financial assets, all put together. So this is a kind of a proposal, but it directly comes and hits the individual insolvency professionals. So far, only the law permitted insolvency professionals to be individuals, even if an IPE is there to provide supporting services. So now in this discussion paper, certain kinds of arguments and reasons have been provided why not the insolvency professional role be given or be taken up by an entity. When they call an entity, only these three forms of entities they are recognizing. Why not the entity also does the role of insolvency professional? So I think the members, the participants would have definitely read the backdrop and the various discussions, the points. Some legal opinion has also been obtained from the government, and where they have also stated that not only a natural person be considered for this insolvency professional role, but also a juridical person, a juristic person can also be considered as an insolvency professional. So a similar kind of a thing has been looked into in other international scenarios also. Also, they have captured in the discussion note what is being done for other professions, including valuation, stockbrokers, IRDAI, insurance brokerage, accounting and secretarial professionals. Like we have practicing company secretaries, practicing CA, ICMI, all those professionals also. And it is also prevalent in other countries as well, as quoted in page number 4. Are we there? Yeah, we are there in this page. So what are all the benefits it is quoted for such entities to perform the role of insolvency professional? Is that the infrastructure, the legal architecture, and the stability in the firm to deliver timely results for a large corporates going through this ARP, or just imagine the size of a company like Jet Airways or SR Steel, where they had ramifications all over the globe. Aircraft lying in Netherlands was to be considered by the Jet Airways, the team, insolvency professional, COC and all. So in this backdrop, the proposal is actually in very short. You can just go to the proposal. To allow the existing IPs, can you please highlight 28? Allow the IPs to become IPs since they have the infrastructure, only 28. Since they have the infrastructure and requisite exposure in providing support services to IPs, and allow the existing IPs after they are recognized as IP to continue to provide support services to IPs. So with this backdrop, I invite the comments from the members, whether this proposal is going to be helpful for the profession. I have certain views. I definitely feel that, when something is done by one individual is being done by, a collection of persons, always two heads are better than one. So there is going to be a synergy. There is going to be an advantage of a better infrastructure. A firm doing a insolvency process is always on the positive side. But at the same time, whether the individual insolvency professionals, on the other day, I think the chairperson of IBBI was there. He was saying that, this is not going to affect the practicing potential of individual insolvency professionals, because there are umpteen number of cases, on the lower strata, not forming part of a high claims of 1,000 crores or 2,000 crores. There are always companies with 10 crores, 20 crores, 30 crores kind of assets and claims. So for such cases, IBC, it's not, probably appropriate to go to a large corporate insolvency professional. Always an individual professional would be a preferred kind of a thing. So this is the backdrop, and may I now request the participants to share your comments on the way forward for this provision, on this proposal. Sir. Can I ask some of the participants here, who have not spoken? Mr. Mohit Arora.
Yeah. Share my views on this. This is Ramakrishna Gupta from Hyderabad.
Ramakrishna Gupta. Yeah, please tell me, sir.
Yeah. See, if you see the various professions which are presently existing, be it a company secretary profession, be it a chartered accountant, be it a cost accountancy, or even advocate profession, both individuals are practicing as a proprietor and also firms are existing.
Okay.
I think this idea or move of IBBI moving to allow even the corporates with a code of conduct designed so that within the framework code of conduct the entity should function. Okay. I think it is progressive in nature. Definitely for the large size of cases, insolvency cases, you need a lot of manpower. So small individual, we have been seeing in practice, individual may not be having wherewithal to handle the cases where the properties are located at different locations. Yeah. In some cases, properties are located beyond the borders. Correct. So I don't think he can spare time and synergies. He may not have synergies being an individual, irrespective of the manpower which he has in support of him. But entities, definitely large entities, which can have their presence at different locations, so they can take the support of those entities. So this will definitely help in terms of minimizing the costs also for a large entities vis-a-vis individual.
Good. Thank you. Good, sir. Thank you, Mr. Ramakrishna, on your points. It's very clear. And some more views I would like to hear, sir. Mr. Sendil Kumar, would you like to say something?
Sir, I'd like to add a point here. See, why only the existing IP should be allowed? If the intent is to create IPs with larger infrastructure, why can't new IPs, because the already existing IPs are having the requisite exposures, if they can come and form corporate entities, why can't the new IPs can't be allowed?
Good point, sir. Good point. I think there is one kind of a word mentioned in para 28 to start with.
Yes, sir.
To start with, I think the idea is that you have a set of people, IPs already existing.
Okay.
Whether they would like to get converted into insolvency professionals, full-scale insolvency professionals. Probably, I think the IBBI would like to test the waters before going on permitting a regular insolvency professional, corporate form of insolvency professional. Probably it looks like
yes.
Yes. Your point is well taken. If somebody is fulfilling the requirements, even an IP to be formed tomorrow, right? But one thing, Mr. Sendil, it is not a straightaway a kind of a corporate form of IP which is proposed, I think it is a two-stage. First IPE, then it becomes IP. That is what is suggested in this paper. But what you are saying is that why not a straight process?
Yes. Thank you, sir.
Am I right, sir?
Yeah, you are right, sir.
Okay, good, sir. Good point. Thank you, Mr.
Thank you,
Sandeep. You are from which place,
Yeah.
Mr. Sandeep?
I'm from Bangalore, sir.
Bangalore. Good. I'm hearing a lot of people from Bangalore.
Sir, I just want to add one point to Mr. Senthil, in support of this point only.
Yes, sir.
So if the new IP, if it is forms with the IPs who are got already exposure or experience in the things, that can be allowed straightforward. That is one suggestion. If it is like, we can recommend actually.
Okay, sir. Okay. Instead of going through the IPE process, straight away to IP process.
Exactly.
Okay, sir. Okay. I have a few more professional colleagues on the screen. I think it would be nice if you unmute your video, join the discussion, share your point of view. There are so many people. I would like to hear all of them. Don't be mute spectators. Rajesh Gupta.
Yeah, sir, there should be some threshold limits for cases for IP. Only large cases should be referred to the IP. This may be on the claim side, like 2,000 crore or more, or like that. Yes.
Do you suggest any a kind of volume size or something for such IPs?
Yeah, says 2,000 crore claim size.
Oh, above 2,000 crore claim will go to such
IPs.
Okay, sir. Okay, good, sir. Good suggestion. Why did you choose 2,000 crore, sir? Why not 1,000? Why not?
I think it is reasonable, sir. Yeah. And secondly, if the registered IP has to be allowed, then their net worth size has to be below 1 crore, which is existing 1 crore limit is there. It should be brought down to 10 lakhs.
Okay, 10 lakhs.
So that the more IP can be formed and not 140 or 150 IPs shall be there. More and more IP shall be there.
Okay.
Because at present, in the case of chartered accountant or company secretaries, there is no net worth criteria is mentioning for that.
Okay.
And 1 crore is more than the press rate.
Okay, Mr. Rajesh, you are from which place, sir?
Delhi, sir.
Delhi.
Yeah.
Oh, okay. Thank you, Mr. Rajesh. We have taken note of your point suggestion.
Okay, thank you, sir.
Sir, some more representation, participation.
Yeah, Mr. Rajendran, can I come in?
Yeah. Your good name, sir?
Good day. Sanjeev Pandey.
Sanjeev Pandey. Yes, sir. Please tell me. From which place?
From Mumbai.
Mumbai, yes, sir. Good.
Yeah, so basically, I just second the idea that there should be a minimum limit for IPs to get the cases, and at the same time, both IPs and IPEs both should be able to compete. It should be left to the banks or the FCs to decide whom to hire. It should not that anything about 2,000 crores should only be the domain of IPs. So let it be a competition between an IP and an IPE. That is one.
Okay.
And minimum threshold, I think 1,000 crores should be fine, because assets and should be linked not to the outstanding, but rather I think if possible to some value of the assets or something.
Okay.
And then regarding the fees, IP fees, the IBBI is given some minimum threshold. So I think they should also give some complexity factors over and above that, so that higher fees can also be worked out.
Okay.
1.5 lakh, 2 lakh is the basic minimum for a kind of asset where the unit is not operating, it's a defunct. So you get the minimum. So that is the kind of minimum.
Okay.
Now you have an operating unit having multiple units in multiple locations with large number of employees. So that should having multiple litigations. It's a listed company. So all these factors add complexity to a particular CIRP.
Correct.
So I have suggested one matrix, which I can maybe share with you later. So
Okay.
where some 8-9 factors can be added on top of this basic fee,
Okay.
and some kind of weight can be added to those factors, like
Okay.
0.5 or 1, 0.25, depending on the factor, so that a multiple of the basic fee can be decided to arrive at the minimum fee.
To arrive at
The minimum threshold, yeah. So anything
Minimum?
above that, yeah.
Oh,
Because this minimum is for the basic kind of transaction where RP has to do the minimum job, like a closed unit. He will take over, doesn't have to run the unit, doesn't have to do all sort of things. But there are same size of unit can have different kind of complexities.
Okay.
So that is my say. Thank you.
Sanjeev sir, we will be very grateful if you can open up your camera also, sir.
Yeah, we are not able to see you, Mr. Sanjeev.
Okay, 1 minute.
Hope all is well in Mumbai.
Yes. I
Okay,
just
okay.
retired from SBI. I know, I think Mr. Indra know me well. So he's not
Yeah,
able to-
that's what.
Sir, that's why I requested
Yeah,
you, sir.
Yes, I also doubted. He was, yeah, Mr. Sanjeev.
Yes, yes.
Sir, thank you very much.
Oh, yeah. Yeah, Mr.
Yeah.
Sanjeev, I'm able to recollect now. Yeah, good, sir. Good. Oh, very good. You
So-
were in State Bank of India prior to, and
I
IBBI
was
as well.
head of IBC division. So
Yes.
I just retired last month. So
Good, sir. Good. Sir, we have some very good set of people in this platform who were all insolvency professionals and also from banking experience. So I think we were just wondering, when you were saying so many factors which can be taken into account for minimum threshold.
Yeah.
So that's good, sir. I think you can definitely share it. That'll be very useful.
yes, because we have worked, I think I worked on a fee model for the bank sometime in 2019, where I created a very detailed matrix for calculation of fees.
Very good, sir. Very good.
Somehow, because of the stiff competition among IPs, that model did not pick up, and no guidance from IBBI also. That was another factor. So this discussion paper came. So I think you should see those 2 paragraphs. The one of the large bank have suggested like this. So that was our suggestion from SBI. Why not have minimum threshold? Because people were just at the bracket level, they were just competing 20,000, 30,000. But that is not the kind of work IP has to do.
Absolutely, you are right.
They should have a minimum threshold.
Yeah.
But now we have a minimum. They should have something like, you agree, there are like SR Steel is a case, and then there may be a case like Lenco Infra where there is nothing, no asset as such.
Correct.
Size, but Lenco Infra, because it was a holding company on. So no asset, nothing to be operated. So you cannot compare the fees of both.
Correct, sir.
Complexity, like a listed company requires so much of involvement of RP.
Absolutely.
Number of application, number of employees, number of products, everything adds to complexity. Number of locations. So that is why I suggest that we should suggest some kind of matrix to IBBI, so that tomorrow again the IPs don't compete without getting into the details of these factors.
Correct. Absolutely, sir. Well taken. Thank you very much, Mr. Sanjeev Pandey, sir.
Thank you, sir.
Thank you. Any other comment from the team members? Should I go by the names appear here on the screen? Mr. Mohit Arora, I called. Mr. Hansraj, Vanisha, Atul Grover, Saranya.
Yeah, I just want, with your permission.
Yeah, Dr. Alagrao, sir, please. Most welcome, sir.
Yeah, regarding this criteria of, giving the things which Mr. Rajesh Gupta and other friends already suggested, I do endorse the same. But ultimately, it should be the criteria like big fish should not eat the small fish. I mean, reservation for individual insolvency professionals also to be entertained or encouraged equally, because tomorrow everything should not be like monopolized under some IPs. This danger we should be kept in mind. So IP's criteria parameters, one is that amount which Mr. Rajesh Gupta told, we can add, if the COC size is more than 10, like the 3-4 parameters we can recommend, it should be the part and parcel of the regulation. Second thing is, if you see, high courts may generally in the courts, junior judge will take the support of senior judge, designated judge, like that. Today also, IP, individual insolvency can take the support of IPs. That concept should be continued. And for that purpose also, more elevation and elaboration provision should be there. Just now, what is happening is, it is only a relation between IP and the insolvency professional entity. They are taking services, but that should be more officialized so that this concept of what is the purpose of this discussion paper, and that can be more elaborated. So one way individual insolvencies, another way IPs, both can be streamlined, and they can do better service to the community. This is what my suggestion.
Good, sir. Good. Thank you, sir. Thank you. Well taken, sir. If I may just add one point for the benefit of discussions, in the analysis part of it, I think the IBBI has added some words, the benefits part of it. I think para 26, if you can highlight it. So you just run through that paragraph. I'm not going to read the entire one. It talks about, the structural benefits of a juristic person to become an IP. On one hand, it will institutionalize the insolvency profession. On the other hand, it will bring forth the benefits of a stronger governance system. Thus, it is envisioned to address the issues pertaining to limitations of an individual in performing myriad and complex tasks, addressing concerns of susceptible behavior of an individual, consequent compromise in the conduct of the processes. The institutional design of the entities would assist in better conduct of the processes owing to their resourcefulness and corporate governance and risk management mechanism. I think the kind of wordings used in this process definitely talks about a collective responsibility. So the possibilities of a mistake or a mischief or a wrongdoing are minimized, which can be possible in the case of an individual insolvency professional. We are seeing a lot of orders being issued by IBBI, disciplinary proceedings, day in, day out. We are getting a lot of cases where, even the license AFA of insolvency professionals are all being suspended for some time, for 6 months, 1 year, 3 years also I've seen. So if it is in the case of a corporate entity, I think definitely there is a case for encouraging, of course, with a lot of check and balance mechanism. I fully agree with Mr. Dr. Agalad Rao. There should not be any kind of, the larger, IPs consuming the smaller ones, depriving of the professional avenues for practice for the individual insolvency professionals. I think definitely that is the right point. In this context, do we have some more? Do we have Mr. S. Venkatraman? Is he joining? Okay. So, because this is a sensitive issue concerning all the insolvency professionals, I think Mr. Venkatraman has joined. Sir, Mr. Venkatraman, being again a banker, insolvency professional as well, we were discussing about the pros and cons of the insolvency professional being an individual or a corporate entity. So some views have come that there has to be certain threshold for such corporate IPs to be given assignments above claim size of 2,000 crores or above COC size of 10 numbers, something like that. And Mr. Sanjeev Pandey, I think we were, glad to have his participation. He's also an ex-banker and also from IBBI perspective. So he has given a metrics, a kind of a, different criteria, possibly with a different weightage, based on which the cases can go to a corporate IP. Do you have any suggestions, sir? Do you have any views?
Sorry, sir. Since I'm in the vehicle, initial part I lost. No. You wanted to know whether any threshold can be fixed for IP or what?
Yes, sir. I think the general opinion is that let a corporate insolvency professional firm exist, no problem. But let the area be carved out separately for them and separately for the individuals, so that the larger one, does not encroach upon into the smaller ones area. Rather, if I put it in other way, it's not like the might is right. So both of them should have the right to exist, and they have their own area of professional practice and delivery of their performance.
Okay, sir. Okay.
Is it that coexisting of these two is perfectly all right, or should there be any rigid kind of a thing that for example, there is a fear that big fours, large multinational service firms, they will be able to take advantage of these provisions and all large cases might go their way. This could be a legitimate worry from the individual insolvency professionals. Similarly, lenders may be comfortable to give IBC matters in the COC to a corporate insolvency firm, professional firm, rather than individual insolvency professional. Okay, so how do we go about it? By giving certain kinds of a threshold for IP as a corporate entity can handle only sizes of this much, something like that.
No, say okay. Say definitely the doubts raised or what you have said, there is a possibility that the big four or big five, whoever it is, they are likely to garner a major share of business, that to the high volume business, and the smaller ones may be going to the IPs. But there itself, there is a doubt because the bankers say ultimately the banker's responsibility is to recover, and whoever is they expect to do a better job. I'm not saying the individual IPs will not do a better job, but by perception, they feel that the big four or an IP entity will have better manpower, resources, and other things. So the possibility of recovery and reporting and other things will be better. So the bankers' inclination could be move towards big four and so IP entities. So IP's preference could be less. But no, the other point is whether we should recommend to IBBI to have some kind of a threshold. Up to this should be only entertained by IPs, that is individuals, and beyond this should go to IPEs and or big four. I think then it becomes some kind of a restrictive things. Say then we are depriving a corporate debtor, and I mean financial creditor, of not choosing his own thing, where he is forced to do that.
Okay.
But, okay, if such a step is possible, it is a welcome step, but the bankers may not like it. So only bankers may not like it. So say that this doubt of whether they will favor only the IPEs or the big fours. No, they will also part of the IPE only. Yes, it is there. Definitely, they would like to have preference over them compared to individual IPs. Definitely, there will be a threat going forward. This is what I perceive in the long run, because their perception is more and their experience also will be better with them, rather than going with some individual IPs for the smaller cases.
Okay. Thank you, sir. Thank you. Sir, Mr. Nageshwaran, sir, I have one question to you.
Yes, sir.
In this scenario of moving towards a corporate insolvency professional firm, I do agree that a company form is fine, an LLP form is fine, but we also talk about a registered partnership firm. Okay, so how is it effective that a registered partnership can also become an insolvency professional, but how do they bring corporate governance? How do they bring efficiency in the process? Why not we say in the proposal that only companies and LLPs be allowed, no registered partnership? Would it be making any sense to say such kind of an argument, sir?
Yeah, actually already in the banking parlance, most of the partnership firms are asked to convert themselves into a limited company for the convenience of compliances, follow-up and things. So when that being the case, I think going to have a partnership firm as a IPE and then asking them to discharge as an IPE may not be really working out, because as you rightly told, the compliance part of it could be a problem. That is one of the reasons why the banking sector themselves are nowadays asking the partnership firms to get converted into a limited company. So with that being the situation, this could be a real risk. Yeah, sir.
No, my view is bankers are preferring instead of partnership, private limited, or that is when they would like to take exposure on the entities, because the recovery, compliance, and other things. Because when they lend, their perception is this: when no partnership firm is an IPE, when they are going to handle a case for a bank, I don't think that will have a deterrent for bankers to entertain a partnership firm which is an IPE. That is my view.
Okay.
Because while lending only, the bankers' perception is, because partnership firm, even though there is no jointly and severally they are liable, because the compliance part, reporting part are more stringent in the case of private limited company or companies. They prefer to have that kind of a structure. Here IP is not, unless they lend to IPE, then their perception, like Mr. Nageshwaran was mentioning, they would like to have a limited liability company or a partnership, private limited company or a company, only when they want to take some exposure on that. Otherwise, I don't think they will have any restriction on entertaining IPEs over a partnership firm.
Okay. All things on the same footing. If a large case, for example, a size of a 10,000 crore claim is for up for grabs, and the COC is going to decide whether a corporate IP or a registered partnership firm IP. If it comes to that kind of a question, sir, I have a feeling if the bankers are really doing a due diligence, all details about that corporate insolvency professional will be available in the website of Ministry of Corporate Affairs, whether it is LLP or a company. But if it is a registered partnership firm, I don't think right now any mechanism, Mr. Raghu, is there any mechanism to pull out the last year performance, last year P&L balance sheet of a registered partnership firm? It's not there. So to that extent, the lenders might prefer a real corporate. I don't know, when they call it an entity, registered partnership firm may be an entity, right? It can be sued or it can sue or on its own name. It's a separate entity, it can own assets, all those things are there. But still, coming to a compliance part of it, somebody wants to do a due diligence on them other than their own website, then I think it makes some difference between the real corporate and the registered partnership. Well, sir, I think that's my...
Sir, shall I say something?
Yeah.
No, say currently also, if your bankers are inviting no expression of interest, they are only looking at how many cases you have handled, similar and what is your experience or something like that, rather than going by the entity's balance sheet or any other thing. No. So similarly, when they are entertaining about the ARP, their expectation will be how capable you are in handling such kind of cases, how many cases you have handled. Supposing a private partnership firm, assuming they have handled good number of cases with multiple banks and other
partnership firm. Yeah, you are right, sir.
And even though their balance sheet, the balance sheet is not worthy looking at, but their experience in handling many cases are there and successful cases are there. Probably they would like to entertain them rather than going for a big companies.
I do agree, sir. I think, Mr. Nitin, even going by the statistics of the IPs currently registered with IBBI, I have seen more number of private limited companies next to LLPs, but not many partnership firms. Are very, very less or not even one partnership firms. Probably, I think we need to check. I think most of the cases are limited companies. KPMG is a partnership firm. Okay. Anyway, sir, that's for argument's sake. Any other view, sir, from on this point of view, Mr. Satiraju, are you going to say something? Mr. Satiraju Girajala.
Sir, can we specifically invite comments on proposal number 12, which says the information memorandum and valuation during CIRP, they can be used for preparing asset memorandum. Any particular?
Going back to the liquidation process?
Yes, I'm very sorry.
Oh,
my mind was there on me. Sorry.
What do you want to say on proposal?
Sir, on proposal number 12 says the information memorandum made during CIRP and the valuation conducted during CIRP, they can be used to prepare asset memorandum. So any particular concerns about that?
Oh, that is
there should be a synchronized between the scope of valuation.
Asset memorandum is the duty of the liquidator,
Right, sir.
but taking into account the IM and valuation conducted during CIRP could only be a reference point. If there is a big time lapse between the CIRP commencement date and the liquidation commencement date, such data, valuation data could be stale, could be outdated. My colleague, saying that definitely there is a gap in the period of between these two events.
One is gap and one is the scope.
The scope for valuation.
Yes, sir.
Yeah, the scope for valuation in CIRP period, I think there is a change, in scope as well. In CIRP, they say very clearly only fair value and liquidation value, whereas in the liquidation process, the valuation could be even, into the various categories like standalone, lump sum, parts of the assets, and then, business of the corporate debtor, and then entire corporate debtor as a going concern. So different.
Sir, that are all methods of selling. Piecemeal method, the individual basis and collective basis. Whatever you are referring is on the methods, but the methodology of the valuation is again fair market value and liquidation.
Yes, sir. Actually, that asset memorandum captures those details. Because the asset memorandum captures the details, the valuation has to be done in accordance with the asset memorandum. Then only we will be able to prepare the asset memorandum accordingly. Otherwise, the valuation, what is provided in the CRP process, will not capture the details required in the asset memorandum.
Also, Raghu and Sir, Mr. Dr. Aglad Rao, even for me to put that assets in the auction process, I need to put a reserve price. Okay, I need to put a reserve price. You might see in a lot of advertisements, number one, corporate data as a whole. Number two, the hotel business separately. Number three,
unit-wise. Unit-wise.
So for each item to put that reserve price, you need the valuation of the asset, isn't it? So it goes together. It goes together actually. So only if valuation is done in that manner for each business or for each asset, then I think the auction process will be successful. Now going to Mr. Nitin's question, specific comments is that the timelines being different for CARP and the liquidation, and the scope of valuation being different. The question of using the IM and valuation may not help the liquidator to go ahead with the asset memorandum preparation, right? He also has to take stock of things afresh, and then only the asset memorandum can be realistic. But otherwise, getting the information is absolutely fine. Liquidator shall share the asset memorandum with the SEC after receiving confidentiality undertaking is absolutely fine. That should be welcome suggestion. Nitin, are you okay? Are you satisfied, or anything else is still required?
Sir, I'm okay with it. Sir.
Okay with that. So, gentlemen, we have not heard any lady member present here in this forum. Not even one person has come up and spoken. May I request somebody from the gathering? I don't know, Ms. Deepa is here available. I saw her in the beginning stage. After that, she's not there. So, any other person wanting to say anything on the entity, insolvency professional entity? Yes, Devika, are you there? there but not there. Any other person? Any other member?
Sir, another thing, one of the concerns that was raised was that the impaneled, okay, as of now, there are only 2 impaneled PDAs, right? And they're charging a kind of what was called as exorbitant fee for listing the distressed assets. So it was suggested that if other PDAs can also be allowed. But the contrary suggestion came was that as of now, there may be 2, but in the coming days, obviously, the number is going to improve.
Okay.
So there will be a competition between the PDAs, and then I think cost factor will be taken care of.
Good point, sir. PDA platform for distressed assets. Okay. Right now, the amount of entry fee they are charging, is very high. Listing fees. Okay. If you make it mandatory, then there has to be some competition with more number of PDAs should be available, right? I think NESL is one of the PDAs, right? NESL is one of the PDAs.
Sir, NESL and N junction, 2 are there as of now.
N junction, huh? M junction, okay. Okay, sir. Okay. Thank you, Nitin. Sir, Mr. Sharma, you want to say anything, sir? Are you saying that time is up?
No, sir, we can continue, provided all are having energy. Very energetic deliberations are going on and off. I am listening. Of course, in between some urgent works, I am attending office also, but I am listening, sir.
Sir, thank you, sir. Sir, if I'm okay with the participants, one last comment I would like to make. Jyoti, can you please go to para number 30 of the economic analysis? Allowing entities to act as IP will institutionalize the profession and help to establish better governance framework. This would address the limitations posed by IP being an individual in dealing with large and complex processes requiring concurrent efforts and actions. I think these points have been highlighted by some of the participants. Gradual improvements in the outcome of the process will facilitate fulfillment of objective of value maximization as enshrined in the code in the long run. The last sentence, the major inputs for violation will be through complaints, and therefore the cost of surveillance for IBBI may not be significant. I think this particular sentence, Nitin, in the absence of an IBBI representative here, even now the complaint platform is there. The complaint mode of IBBI getting complaints is still there. Apart from that, I have recently seen another discussion paper for self-sufficiency of financial self-sufficiency of IBBI, where I think quite a lot of huge jump in fees and all has been proposed. Okay, so is it because of such enforcement of compliances or cost of surveillance? Is a cost of surveillance is a big factor? Whether monitoring the individual IPs who are 4,000 in numbers and monitoring of IPEs or corporate IPs, if you say, who are probably in hundreds, whereas this is in thousands. Is it because the cost of surveillance is prohibitive that this option is being thought of because of this additional advantage? Monitoring is easier because all things are in one place, and they handle more number of cases, or they handle high volume cases. Monitoring is easier for them. Is it a pointer to move towards strong IP, corporate IPs? Any comments? So Nageshwaran sir.
Yeah, I doubt even as an IPE who is going to be an IP, account wise or the whatever cases that they have taken, accordingly only the IBBI will have to do the continuation of their compliance work. And suppose as a IPE, they have got around 30 cases. As now working as IP, they are getting 30 cases. Every case will be having a different dates for different things, and the same whatever this ARP form 1 to 7, all those things will have to be monitored on the date wise only. I don't know how this will reduce the compliance follow-up at the IBBI side of it, and that will reduce their cost. I mean, I don't think that, I mean, in any way, unless otherwise they are going to make it as a company itself, or the IPE working as IP will have their own monitoring mechanism, which will in turn report to IBBI, which will reduce the cost of monitoring.
Okay. Not much of a reduction possible because the case wise.
Even in any case, if you have got 5 cases, you are running 5 separate stream only.
But that 5 could be a high value cases probably.
Whatever, if high value cases could be high value or low value, whatever happens, it's a monitoring is case wise.
Correct. Okay, sir. Okay. Good, sir. Good. Any other points?
One point I would like to add. So how do you initiate disciplinary proceedings against the company? Okay, who will be held responsible in case something goes wrong? Who will be responsible? Whether all the directors or individual IP, what structure would be like good?
Mr. Sendil, I think there is an answer in this. You can go to the amendment, page number 8. Yeah, your point is well taken. We are dealing with a corporate entity. How do you initiate a disciplinary proceeding against the corporate entity, right?
Yes, sir.
So can you show that HA?
Yes, sir.
You can see in case of an insolvency professional entity is the insolvency professional, it shall allow only the partner or director who is an insolvency professional to sign and act on behalf of it and disclose to the applicant, the adjudicating authority and the committee. Actually, the wordings used here, Mr. Nitin, may take note that, some words like committee and all is coming here. What exactly is the committee we need to see? Probably committee of creditors, it means this is in regulation 7, no?
Yes,
regulation 7. The extent of capital employed or contributed in a company or a registered firm or a liability LLP by the partner, as the case may be, who would sign and act in respect of relevant assignment for the company. So there is a fixing, like, you have a chartered accountant firms, the firm is having a registration number, and then you are having individual partners as well. So for a case of an audit assignment, is the firm signing or the individual partner signing? The partner under the name of the firm. Who is responsible? The partner. Okay, in chartered accountants regulations, whatever is there different, it could be, I don't know. But here, the next one is very relevant. Point number 3. The insolvency professional entity, which is the insolvency professional, shall be liable jointly and severally, along with a partner who signs and acts in respect of an assignment handled by the registered partnership firm or LLP. Okay, so be liable along with the director who signs and acts, the next point, in respect of an assignment handled by such company, which is registered as the insolvency professional. So, Mr. Sendil, for each assignment, they have to pin down one particular person within the entity. Yeah, and that person along with the entity will be liable.
Right. Okay. Thank you, sir.
Yeah.
So, sir, as I'm reading the 4th clause, it says be liable along with the director. So it is a joint liability, not a several liability. In case of a director.
So it is a joint liability, right?
Right.
Yeah.
So it is
jointly and severally, yeah.
You mean to say other partners are also equally liable? Sir, partnership firm or LLP, partner who signed, what about other partners?
Sir, when they say the company or the corporate entity, then all of them are there in that as well, no?
It's
And
like officer in default concept, sir.
Exactly, sir. You are right. You are right. Under Companies Act. And one more provision, sir. What is the a kind of a differentiation from an IPE? Morphing into or getting converted into an insolvency professional entity, IPE to IPE, right? In IPE, you can have majority of the directors to be insolvency professionals. Okay, not all the directors, not all the partners need to be IPs in the IPE form, currently existing IPE form. But if it wants to become an insolvency professional, then all the directors, all the partners have to become insolvency professionals. So they are all on the same footing. Okay, so you cannot differentiate an executive director and non-executive director in a company. Similar to that here, all the people will be insolvency professionals. Am I right, Nitin? Am I right, Dr. Aladrao, sir?
Yes, sir. You are right. You are right. It's see, prima facie partner who signed. You are talking on the liability point only, no?
Not only liability point of view, the composition. I think you can go to that first page. You can see that all the partners are directors. Highlight it. All the partners are directors, as the case may be, are eligible under clauses A, B, C, D, E, F, and G of Sub-Regulation 1. We are talking about Regulation 4 here, I think, right? Right. So Regulation 4 talks about a person should not be a minor, person should not be undischarged, insolvent, willful defaulter, all those things will be there. And a person has to be a qualified insolvency professional. So he's not a fit and proper person. He should not be a person with disability in the thing or no. Integrity, reputation, character, all those things are there. A, B, C, D, E, F, G.
Sir, in the HA itself, in the last one, where it was there in the HA, the last one says the director who signs along with the director who signs and acts in respect of an assignment. That means every assignment can be handled by one director only. So everybody has to be a director.
That is for a private limited, sir.
Yeah, limited. I'm talking about limited company. Earlier also we were talking about how because the question was in a company, what will happen? If it is a company, what will happen? Now the company, the director only can take up the assignment. So that means everybody need to be a director.
Point 3 is for LLP and registered partnership firms.
Yeah.
Point 4 is for a company.
Director. That's what there was a question asked. No, in the case of a company being an IPE and IP, what will happen? Because he is a director.
Sir, assuming there are 4 people in an IPE right now, out of whom 3 are insolvency professionals, right, in an existing IPE, to get itself converted into a full-scale insolvency professional corporate entity, then this will not be satisfying the requirement. The 3+1 will not be satisfying the requirement. All 4 has to be insolvency professionals, number 1. Yeah. Number 2, assuming it is a corporate form, a private limited or a limited company, then all 4 are liable, right? Not only the person who is signing for the assignment, all four are liable. The company is also liable. Am I right? The specific question they were asking is, the other directors who are not signing for that assignment, to what extent their liability has it been clearly spelled out? Mr. Nitin?
Sir.
I think that point probably could be highlighted to the IBBI. It is talking about the person who is signing and acting in respect of an assignment. He is liable along with the, I think the top one, it is talking about the company, the entity being liable along with the other, along with the director who signs. Now, who is not signing, what is this liability?
Entity, they are liable, but the individual is not liable. As individual, you are not liable.
But when the entity is penalized or punished, so all of them will be there now in the punishment.
Impact will be there. The impact of that liability will be there on the entity.
Yeah, probably on this score, what Mr. Sendil raised this point, a little more clarity could be better. For example, Mr. Nitin, I'm there, Mr. Venkatraman is there. Maybe I did wrong, something in my duty as a insolvency professional when I was signing this. Why he should be made responsible for such a lapse on my part, even though all of us are together in the same company. So vicarious liability, whether it can be pinned on one person or on all the persons.
The wording is very clear.
There is also a question on the chat box. One Mr. Mohit Arora has asked, OPC, one person company will also be taken as an entity. It's a question which I've asked in the chat box I just now saw.
The very fundamental thing is that, individual IPs are susceptible for compromise. Am I right, sir? I think the words used there that, individual person is susceptible for compromise. That is why they are going for this thing. Yeah, it's a good point. Why not?
Question is, OPC is also equivalent to a limited company.
Recognized. It is already
recognized and it is ROC registered.
No, but the thing is the financial creditor has to choose.
That's what. No, the question asked, and that is OPC is also in the same footing. That's a question I just now saw in the chat box.
Sir, given the context, I mean, in case he's an individual, then he'll take up as an individual IP. I mean, instead of giving him assignment as an OPC, so it would be better that he takes up assignment as an individual IP.
I mean, whichever is the thing, then it is left to his choice. He can take it under OPC name or under IP name.
Sure,
As of now, no OPC is registered as IPE, I think.
I think Dr. Alad Rao, sir, may help in the definition of a person. Go to the first page of the paper. An individual, undivided family, a company. Okay. What is the meaning of a company? Does it include an OPC?
Plain reading, it includes OPC, sir. Because as per the Companies Act, OPC is also company.
Company.
That is one thing. But when you go for other registration criteria and other things, it talks about only private limited and limited.
Correct.
OPC is also private limited, but the only thing is being one person company need to be examined, because the purpose of total regulation itself to give the 2 or 3 people that may be
broad-basing the process.
So in connect to objectivity, then purpose will be defeated.
Correct.
But in OPC also, sir, shareholder may be one person, board of directors may be 2-3 persons, because if you see the regulation, just now sir also pointed out, on behalf of private limited company, it should be a director. So in OPC, shareholder may be single shareholder, but board may be 2-3 board directors. That is allowed as per the law. So we can interfere in that manner. So if they got broad-based board of 2 or 3 members who are insolvency professional, still OPC can also manage. This is what a recommendation may be made, or else because same person may not be director also, we can put the condition if OPC hold by an insolvency professional, he should be director, and also other insolvency professionals may be as a directors, more than 2. That may also be allowed for this purpose. Like that, we can recommend based on our discussion.
Sir, Dr. Aladra, sir, please take it to serial number 6, page number 8.
Okay.
Where for the purpose of this IPE to become the just highlight its sole objective in the highlight. It's for the purpose of becoming a insolvency professional, corporate insolvency professional. These 2 things are mandatory. The IPE, the sole objective is to provide support services to insolvency professionals or to get registered as an insolvency professional. 7, subject to meeting eligibility requirements under regulation 4. I think this is what we had seen. Next point you see, sir, majority of its equity shares and voting rights are held by insolvency professionals.
Perfect.
If you put the OPC here, the entire shares will be held by 1%. Okay, still it meets, but the wordings are plural, are held by insolvency professionals who are directors in case it is a company.
Okay.
So I think reading all these things together, I think OPC might have to be left out in the process. I think they cannot get into the bracket of
in legal interpretation, still OPC will come, sir. In fact, in spite of this, whatever you told also, majority means it includes 100% also. So a single insolvency professional having 100% will come to the criteria of this if it is an insolvency professional. And in the OPC also, we can have the board of 2 or 3 directors. So broad-based board also can be achieved. So I do agree with you. Intention is to have a legal structure with a broad-based board and shareholders. But literally, today still based on these regulations, whatever mentioned, OPC is also equally eligible. So we need to mention if the case of OPC, board should have the 2 or 3 directors, and insolvency professional who is a shareholder, he must be one of the director. Like that we can recommend, or else totally it should be excluded. Excluding may not be correct because the law is unless otherwise except OPC word mentions, otherwise by plain reading of this regulations and paper, OPC is allowed with all conditions, whatever they mentioned, eligibility criteria conditions also.
I think that's a good discussion, sir, of this OPC. Sir, to sum it up, Mr. Nitin, in this discussion on this entities to become insolvency professionals, I think 2-3 points which came up. Number one, why only existing IPs? Why not newly constituted IPs? Number one. Number two, threshold and then criteria for carving out a specific area of practice for the corporate IPs and the individual IPs. And the third point is on the OPC concept is also possible to fulfill the definition and the requirements. So why not the OPC, is specifically, it has not been mentioned anywhere, but it looks like, as Dr. Aladarao said, it is possible for an OPC also to fulfill all these requirements. It is the market finally to choose whether you should go with an OPC or a private limited company with a broad-based shareholding. Shareholding, whether it is material, only the board or directors, insolvency professionals may be the material thing. So it looks like, Mr. Mohit, Mohit, you said Mr. Nageshwaran?
Yeah, Mohit Arora, he is on the screen.
Where is Mr. Mohit? Good, good. Thank you. Thank you for pulling out this OPC concept here, Mr. Mohit. It looks like probably, that's a workable kind of a model. Only thing is, Mr. Mohit, the entire share capital has to be brought by you, and 1 crore is the amount right now, Mr. Mohit. So be ready with 1 crore of rupees. We'll all be part of the board of directors. Okay. Okay, good, good. Nitin, I think we should sum up the entire thing, and I really appreciate the participants who are all here, and in special thanks to Dr. Aladarao, Sanjeev Patikar, and Mr. Nageshwaran. Mr. Venkataraman, by the way, he has just joined me here in office. So, Mr. Ramakrishna Gupta for sharing, Sendil and Mohit. Mr. Nitin, would you like to, is there? Mr. Nitin is there? Or Mr. Sharma?
Yes, sir, I am here, sir. Sharma, sir, would you like to deliver the closing remarks?
Actually, sir has to go to debate competition for monitoring.
Yeah, there is a student month, sir, ICSI. So excuse me.
Please, sir, please. Please, sir, aap kijiye, please. Sorry, please. Aladarao, sir, requesting you to deliver.
Number, what is there? Yeah. Anyway, it's wonderful discussions, friends, on the round table. And though discussion was meant for something on the corporation of insolvency, but we got a different points which was emerged, especially on the OPC and also on the disciplinary mechanism. Couple of other points which are connected also. If we are given a food food for thought, and it's really adds value for the framing the regulations and mechanism. Thanks to all the people, and thanks to especially the speaker who was, I can say, speaker or moderator, sir, for your best efforts and excellent efforts put to you today. And along with your team, I can see that your total team is there. All are worked as a team. That is what IBC intends, teamwork through this corporation program, which you have proved through today through your discussion itself. Thank you to Nitin ji and other people also who are coordinating.
Thank you so much, sir. Thank you, Dr. Sir.
Thank you very much, sir.
Thank you so much. I think we had a nice celebration, sir. Rajendran, sir, I think you brought many points for the thought-provoking discussion. I think this discussion had a lot of inputs for all the participants.
Thank you so much, Mr. Ramakrishna, sir. Thank you. Thank you, sir. Thank you.
Thank you very much, Mr. Rajendran. It's an excellent presentation, and it is going forward how the law is going to emerge. So a lot of inputs, various input schemes. Really, I got more enlightened.
So, Jay Kumar sir, thanks to you also for your interactive things. So nice of you in middle, whatever the points you shared, so nice of the things, and other participants also. Rajendran sir, who are your team members? Can you please spell out? We want to say thanks personally to them also.
Thank you, Dr. Labro.
All of them are here, sir. Mr. Raghu, Jyoti, and Sudhir. And of course, Mr. Venkatraman sir is there.
Yeah, Venkatraman garu, Sudhir garu, Sumati ji madam. Everybody, thank you on behalf of our Insolvency Professional ICSI. Okay.
Thank you so much, sir.
Thank you.
Bye, sir. Bye. Thank you.
Right, sir. So thank you very much. Just one last point. So in case anybody wants to mail any suggestion from their end, they can send it to, I have put in my email ID there in the chat box. So they can send it, but it has to be sent by 4 o'clock because by 5 or 5:30 we'll be finalizing and sending it to IBBI.
Okay. What is that? Tomorrow is the last date, na?
So today is the last date.
Today is the last day. Okay.
Today is the last date. Yes.
Okay.
Fine.
Thank you.
They can send individual. Yeah. Thank you.
Thank you,
So
sir.
thanks to all the dignitaries. Thank you very much.
Thank you, sir.